Good morning, we're on the record. Good morning, everyone. As chairperson of the Alcoholic Beverage Control Board for the District of Columbia, and in accordance with DC Code Section 2571HC of the Open Meetings Act, OMA, I am welcoming you to the regular scheduled meeting of the Alcoholic Beverage Control Board. This meeting has been conducted pursuant to guidance made available by the District of Columbia's Office of Open Government regarding electronic meetings held by public bodies. Electronic meetings by the ABC Board are also authorized pursuant to Section 2577A of the DC Code. Pursuant to the OMA requirements, notice of today's meeting was provided 48 hours in advance of the meeting on ABRA's website and on the District Central meeting calendar. The notice includes the time, date, agenda, and call-in or login information for public participation. This electronic meeting is being hosted by a WebEx account provided by the District of Columbia government. Please address any questions or complaints to the OOG at opengovoffice@dc.gov. My name is Donovan Anderson. I'm chairman of the board. I would like to introduce the other members of the ABC board who are also participating electronically. Please respond when I announce your name. Mr. James Short.
Mr. James Short, present.
Mr. Bobby Cato.
Bobby Cato, present.
Ms. Rafi Crockett.
Rafi Crockett, present.
Ms. Jenny Hansen.
Jenny Hansen, present.
Mr. Edward Grandis.
Edward Grandis, present.
The board has 6 members in attendance for the conduct of business today, and that constitutes a quorum. Before we get underway with this morning's calendar, I need to make a few instructions very clear so that the conduct of this hearing is understood by everyone. There are 4 cases scheduled for this morning's calendar. Once your case is called, I will take a moment for our IT specialist to elevate the rights for each party to enable their camera and microphone. Then and only then will you have the ability to enable your equipment. If your case is not being heard, you will remain mute and your camera will be disabled. At the conclusion of each case, the parties will have the option to leave. If the party chooses to stay, all cameras and microphones for the concluded case will be disabled. Should you have any questions or require technical assistance during the hearing, please submit them using the question and answer feature. Our first order of business today is the show cause hearing status for case number 22 CMP 00001 Mirror Lounge, license number 111950. This case has been canceled. The parties entered into an offer in compromise on March 23rd, 2022. See board order number 2022-124. The second case in our calendar, the fact-finding hearing, it's Whitfield Entertainment Group, license number 120468. Ms. Foxburn, good morning. Can you please elevate the rights of the parties in this case, please?
Please stand by. Maria Murphy, your rights have been elevated. Anisha Hodge, your rights have been elevated. And Sean Townsend, your rights have been elevated. That is all, Mr. Chair.
Good morning. Thank you. Mr. Townsend, can you please elevate your? Good morning, everyone. I would like the parties to please introduce themselves for the record. It's my understanding that Mr. Townsend has entered his appearance. So can you please spell and state your name for the record? Starting with you, Mr. Townsend.
Good morning, Chairman and members of the board. My name is Sean Townsend, SHAWNTOWNSEND, and I'm here on behalf of Whitfield Entertainment Group. And I believe Maria Murphy and Venetia are on as well.
All right, so I'll have Ms. Murphy, can you please spell and state your name for the record and your relationship to the establishment, please?
Hi, my name is Maria Murphy, Maria Murphy, and I am the president of Whitfield Entertainment Group Studios.
Good morning, Ms. Hodge. Can you please spell and state your name for the record and your relationship, please?
Good morning. My name is Venisha Hodge, Vonisha Hodge, and I am the CFO at Whitfield Entertainment Group.
Good morning. All right, good morning, everyone. This is a fact-finding hearing on the Whitfield Entertainment Group, and the sole purpose for the fact-finding hearing is to establish whether the applicant qualifies as a multi-purpose facility under 25-113G1. The board's practice has always been to allow legitimate multi-purpose facility applicants to proceed forward to the public comment phase. To establish itself as a multi-purpose facility, the applicant needs to satisfy the board that it is one, either a legitimate theater, university, museum, conference center, art gallery, or other facility for the performance of sports, cultural, or tourism-related activities, or two, an indoor park, building, or facility that primarily serves as a recreational playground or a workspace. As just to inform again the parties, this is a fact-finding hearing. The board has not made any determination. The board is gathering information, and so whatever information the board gathers today, we will make a determination, and the determination that the board will make is to state whether or not this is a proper license class for this facility, or the board might inform the licensee that they should apply for a different type of license class. If the board determines that this is a proper license class for this facility, what the board would then make a recommendation to the agency that the facility be placarded. So that's basic. Those are basically where the board is today. We're just gathering information. At a fact-finding hearing, parties are not sworn. We're just gathering information. The board at a fact-finding hearing cannot legally require an applicant to do any specific action. We can ask if you so desire, you can say yes or no, but the board cannot legally require the applicant, or in this particular case, the applicant, to take any specific action. Now, is everyone understood where we are today?
Yes.
Yes.
All right, so who will be speaking? Who will be speaking? Are you Mr. Townsend or are you Ms. Murphy?
I believe it'll be a little bit of both, but you can start with me, sir.
All right, fine. Good morning, Ms. Murphy. Welcome. And you have applied for a CX license. So can you please tell us what's your business plan?
Sure. So we are a startup entity. We put together our business during for the last 2 years during the pandemic, and we went started operations effective August of last year. And our business plan is that we are going to be, or that we are, excuse me, I'll call it a full service entertainment company. We offer film, music, special events. In our building, it is, we touch upon all the areas in which you mentioned, you know, for applicable for a CX license. Not only do we have special events, but in addition to that, we are in negotiations or have been in negotiations for offer stage plays, concerts, corporate events. We are building recording studios that will be on our second floor, and we will be the second recording studio in the DC proper. There's only one other smaller studio in DC. In addition to that, we we're negotiating with the NBA 2K just to run their gaming league. So I believe that we cover multifaceted areas.
Now, I'm aware that the ABC board had approved some temporary licenses for your establishment. And so, just for the record, what it is that you had submitted temporary licenses that were approved by the ABC board. So can you explain to us what were those events?
Oh, sure.
What events were those for, please?
I don't know if everybody watches Netflix, but there's a show on Netflix called Bridgerton, and it's a Netflix and Shonda Rhimes Productions. And what they've done is turn the show called Bridgerton, and it's called The Queen's Ball, into an immersive live art experience, and that is currently at our studio. It will be in the studio through the end of July, and then we'll segue into another experience, which I'll mention momentarily. But the licenses are particularly for Bridgerton, the Queen's Ball. It's a very elegant experience, and where people were. Bridgerton takes place in the 1800s, and people come in gowns and 1800 type clothing, and with the wigs that were worn at that time. And so, because it's the Queen's Ball, they do need to be able to serve alcohol and that type. So it's a whole take on in 1800s type live experience. So it's dancing. There's acrobatics, like Cirque du Soleil type acrobatics and things like that.
Now, so is this a type of event that you plan to have at your facility?
Yes, well, we're currently having it now. Yes, sir.
No, I'm saying moving forward, is this a good, I'm asking, is this an example of the type of event?
Yes, yes, sir. So our facility right now is, we call it the black box, because you can create your experience or what you need to have in the box. So this experience will be for Bridgerton through June, and then, through July. Then after July, the black box is going to be transformed into a, it's called Mexican Genius. It's, if you're familiar with Frida Kahlo and her art. And so it's sort of similar to a Van Gogh experience, but it will be the Mexican Genius. That's the type of event that we're moving into right after Bridgerton for the next year. And then in addition to that, it may remain another experience, or we have offers in which we will be filming productions in there, because the soundstage, the black box, is fully soundproof and was initially built for BET for film and production. So we can change the experience of the black box based upon the particular needs. So it can be special events as well as it can be used, for us when we have filming and production.
Ms. Murphy, you've mentioned the black box. And what's the black box?
Well, at least our particular black box is a soundstage, and it's about 17,000 square feet, and it encompasses everything that's needed for film and production. And the reason why it's called the black box is because it can be created into what you particularly need. For the soundstage, it could be built, if we're building it for a film and production, it could have hospital sets or bars, or a house, as well as it then can be transformed into something else that's needed. Backyard scenes, whatever it's needed. It could be transformed into what we're currently having now. So it's just generically in the industry, they refer to it as a black box, because literally, because it's a soundstage, it's all black.
And Mr. Chairman, if I can just add
Yes, yes. Go ahead, Mr. Townsend.
if I can just add briefly that for context, this is the former BET campus where the BET campus was located, and so this is BET, as many of you may know, historically have had a number of events there in the past. Maria and her fiance, who unfortunately passed away from COVID in the winter, they have a vision of creating not only just the some of the experiences that took place at the former BT experience or soundstage, but they are in talks. They have been in talks with a number of networks about filming and producing shows there. They have had a number of events there, ranging from concerts to live performances to just anything involving film. And I'd be remiss if I did not add that we are right next door to the Office of Cable, Film, Television, and Entertainment. And we have been in close talks with them, and they have also been referring us to different companies and producers who have been interested in filming in DC. So not only is it the entertainment, providing the entertainment piece, but we're also providing an opportunity for DC residents to learn new trades, be employed locally here in the city. And so I think it's a really good opportunity for us to revitalize that space that's been dilapidated for quite some time.
Mr. Townsend, I know you stated that there's been other events there, but to the best of my knowledge and recollection, we have only provided alcohol license for the Bridgerton. I'm sorry, for this most current production. So were alcohol sold at the other, are sold or served at the previous events?
So good question. And when we're talking about filming and producing there has not been alcohol served. And on the occasions that alcohol was served, Maria and the staff have contracted with a caterer who is of course an ABRA certified caterer and able to serve the food and the alcoholic beverages as an accessory to the food.
Thank you. Now, will you have any type of nightclub type events at this venue? This is in the sense of bar, live entertainment, bottle service, VIP section, dance floor.
We have had events that have been concerts and dancing events, but that is not, I wouldn't call us that we are a nightlife venue. We, as having a black box and having special events, we do have those types of events, but it's not our day-to-day.
Now, are there any other venue in the city that you would consider yourself, your proposed venue similar to?
I would say that we're similar to Anthem. It's probably the most, because Anthem can be used for multi-purpose type events as well. I would think that we're a smaller type of a Capitol Arena, because there's obviously the core basketball, but they also have special events as well and host concerts. I would think that I would think at some of the colleges and universities where they have various events as well at their facility. And I was remiss with not mentioning that we are in negotiations with Howard University to help provide opportunities for hands-on experience with their students in their film program at the master's level. So
And I would just add that the venue is currently operating as, I mean, in comparison to Arena Stage or the Shakespeare Theater, where we have a live theatrical, play, for lack of better words, taking place right now.
Thank you. I don't have any other questions. Any questions by any other board member? Yes, Mr. Short, I believe you want to ask a question.
Thank you very much, Mr. Chair. Good morning, Mr. Townsend, Ms. Murphy, and Ms. Hodge.
Good morning.
Good morning.
Okay, this question is to any of all of you, but I guess probably Mr. Townsend would like to answer this for us, but any one of you can. Just pretty much for the board and for the record, can you describe this building and describe the building and the community surrounding it, please? Very briefly.
Maria?
Want me? Sure. Our building is about 57,000 square feet. It's 2 floors. The soundstage, in particular, that we are referencing as the black box is about 17,000 square feet. We have currently in the building, we've had, well, some things are under renovation. You know, we've had the concerts or special events. We've had Netflix and MasterClass, and they're producing shows, as well as now, as you know, that we're having the Bridgerton Experience on the first floor. On the second floor right now, it is empty, but we are currently in negotiations and working with an architect to build out recording studios. So we will have 3 recording studios and about 4 podcast studios on the second floor. And we'll be breaking ground on that very shortly. The surrounding area, sir, is industrial. There's actually right next door to the city dump, as well as next door we have the car repair service. Across the way, there's vendors that they produce food. So we have food trucks coming in and out. So it's all commercial around us, as well as what Mr. Townsend mentioned. We are neighbors to the Office of Cable and Television and Film, as well as, I think, the Metro. The Metro is there as well.
Okay, what is the classification that DCRA or the Department of Consumer and Regulatory Affairs, what classification have they classified this building as? Do you know that?
Sean, do you?
What the classification, the building classification is today?
Mr. Short, it's zoned as PDR 4.
Okay, thank you. What is the total occupancy of the building?
1,900, sir.
Okay, and you know I was going to ask this question probably, Mr. Townsend. The number of exits and egress for the building?
I will defer to Maria on that. We probably should have had our building engineer on.
Sure. No, I can tell you, I can count real fast. I know the building very well. I've given a lot of tours. 1, 2, 3, 4, 5. It's at least 6.
6 exits and egress for how many people?
1,900, sir.
How many?
1,900.
1,900. Okay. Also, I guess what I'd like to ask is, have you reached out to any of the community, the ANC, or any of the other persons in the community who might have interest, or do they have opinions if you have reached out to them?
Mr. Short, I've reached out to Chairperson Jackie Manning of ANC 5C over the past few months and have had conversations with her about our interest in applying for an alcohol license. She personally has expressed her support, but obviously she cannot speak for the rest of the commission, and I plan to continue to have conversations with not only Chairperson Manning, but the entire ANC after today's hearing.
Okay, that sounds great. You've done your homework, and I certainly, as a board member, appreciate that. I know the board, all the board members do. again, so is there any build out left to be done, or is there anything extra that's going to be added or taken away from the building as it is now, should this board decide to grant a CX license to you?
The build out that we're talking to the facade, it won't necessarily interfere with or take away from what we are currently offering and what's in our business plan. But there will be some structural designs eventually down the road. We have a plan to, you know, make it look like, you know, more attractive and make it more of a monument, I'll say, of an area of a place of attraction for folks in the DMV.
Okay, so other than aesthetics, which you've just described, are there any other building or construction that needs to be done to make this a very wholesome CX?
Oh, well, other than what I've mentioned, you know, for building out the recording studios, no, I mean, there is a full service kitchen, a prep kitchen that needs to be put in. But it's just that's gonna be prep. And so we'll have warming stations. There'll be no live cooking on the space.
Okay, now, I appreciate that answer. And also, I'm very happy to hear that the ANC 5 is committed to working with you with this. Now, one last issue, and that would be parking. For how many people will be parking or driving to your area, and how would that affect the community?
Sure. Well, we're very fortunate that we have about 484 parking spaces.
I'm very appreciative of that information, and thank you so very much. Thank all three of you.
Thank you.
That's all I have, Mr. Chair.
Thank you, Mr. Short. Any other questions by any other board members? I'll just ask one. I mean, there are many different type of license class that license can be applied for. One, you can apply for a nightclub. You can apply for a tavern. You can apply for a restaurant. And so why is it that you believe that this is the appropriate license class, that the multi-purpose license is, why is it that you specifically want this particular type of license?
Well, Mr. Chairman, I think, you know, Maria laid out several events that have happened in the past and some of the things that we are interested in hosting at the facility in the future. And the events directly correlate with the definition of a CX. We have theatrical, we have cultural events for not only residents here in the city, but folks who are visiting from out of town to the city. We want this place to be another attraction in addition to things that you may visit DC for. This is a place where, excuse me, where we've had boxing matches and fundraisers, et cetera. So it's not just a place where we want you know, patrons to attend to consume alcoholic beverages, but it's more than just a tavern or a restaurant. And I think that, you know, a multi-purpose CX license is the only option that we were interested in at the time as we thought through all of the different types of events and amenities that we wanted to offer to patrons. This is the reason why we're here today, because we think that, you know, the CX license is the right license for this facility, given you have other venues in the city with this type of license that one would argue, one meaning me, would argue that WEG is offering more a more multicultural, diverse genre of events taking place at 1301 W Street Northeast. So Maria, if you'd like to add anything to that.
Yeah, no, Sean, thank you. That I think says it properly. And, you know, in addition, what we are doing, we want to be a place a service to the community. There's so many talented youth and young adults in the area that don't have a place to go to film or to lay a track, you know, at the recording studio. Already we've given away many hours to young directors who can't afford a place to go shoot, and they come over here and we offer that to them. We have already had someone who was interning for me. Unfortunately, because we're a startup, we don't have, you know, money in which to pay people or young interns, and they were able to get a position with Bridgerton full time. So we're offering training opportunities to people where they can, young folks, where they will not then be hindered from getting the job because they actually have experience.
All right, any final comments you want to make before we bring it? Or any final comments you want to make, or any additional questions any board member wants to make before?
Mr. Chair, one last
Yes,
question.
yes, Mr. Short, yes.
I would just like to ask the panelists that are coming before us today, could or would they be willing to submit a floor plan to the board to help us better make our decision?
Of course.
Yes, we can provide that.
Okay, because we can't really ask you to do anything today other than, or make a request to be today. But if you would do that, I think it would help some of us board members come to a better decision. Thank you. That's all I have, Mr. Chair.
All right, thank you, Mr. Short. Any final comments you want to make before Mr. Townsend or Ms. Murphy? I know you haven't spoken, Ms. Hodge, but any of the three final comments that you want to make before bringing this hearing to close?
That's it for me.
No, I just want to thank you for your consideration.
Yeah, just thank you.
Yeah. Well, thank you very much for your presentation this morning. As I stated, the recommendation, what the board will now decide is whether or not, if the board determines that this is the proper license class to apply for, we will turn it back over to the agency for the agency to follow the process, and the process would be that the matter is placarded to inform the community. If the board believes that this is not the proper type of license to apply for, then the board with the agency will make recommendations to you to see what other type of license would be more appropriate for your business plan. All right, so we'll take this matter under advisement, and we will inform you shortly of our decision. Thank you very much.
Thank you, Mr. Chairman. Thank you, members of the board.
Thank you.
Thank you. All right, bye-bye. The next case in our calendar is another fact finding here in case number 21-251-00038, the Shoreham Hotel license number 13816. Ms. Foshman, can you please elevate the rights of the participants in this case, please?
Please stand by. Andrew Klein, your rights have been elevated. Mark Brashears, your rights have been elevated. That is all, Mr. Chair.
Mr. Chair, if,
Yes, Mr. Klein. Mr. Klein, you're on blur, so I can't really see
Yeah.
you because you're blurred us.
let's fix it.
I think it's a matter of you changing your background, Mr. Klein.
Yeah, I just switched cameras, so I hope that.
Yes, that's,
There I am.
before we start, Mr. Klein, is your client here or is it?
Yeah, I was getting to that when I was blurry. So elevate, please, the rights of the area managing director, Mark Roche Garland, sorry.
Ms. Foshman, do you see Mr. You said Garland?
Yes, Mr. Roche Garland. Uh-huh.
Mr. Garland, can you identify yourself through the chat, so we will elevate your rights, please.
His rights have been elevated.
Thank you. Is that it, Mr. Klein?
Yes, it is. Thank you.
All right. All right, thank you. Good morning. Let's have the parties identify themselves for the record. Let me start with you, Mr. Klein. Can you please spell and state your name for the record, please?
Yes, thank you. Good morning, Mr. Chair and members of the board. Andrew Klein, first name Andrew, last name Kline, counsel to the Omni Shoreham in this case.
And who's here with you this morning, Mr. Klein?
Mark Roche Garland.
Good morning,
Mr.
Chair.
Garland, good morning. Can you please spell and state your name for the record and your relationship to this establishment, sir?
Certainly. My name is Mark Roche Garland. That's M-A-R-K. Last name R-O-C-H-E-G-A-R-L-A-N-D. And I'm the managing director of the Omni Shoreham Hotel.
Good morning, and we have our investigator, Mr. Brashears. Can you please spell and state your name for the record and identify yourself, please?
My name is Mark Brashears. That's M-A-R-K-B-R-A-S-H-E-A-R-S. I am a supervisor investigator with ABRA.
Good morning, Mr. Brashears.
Morning, sir.
Thank everyone for being here this morning. This is a fact-finding hearing, and this case was initially, I think this was scheduled a couple of weeks back, but it was postponed until today. And so this is basically a fact-finding hearing. It said MPD found a gunshot victim in front of the Shoreham Hotel. On the date of the incident on November 28, 2021, 5 gunshots were heard in the vicinity of a hotel. A victim was found with gunshot wounds to the buttocks and broken femur. The hotel was hosting an event for the date of the incident. No indication that the shooting victim was. Ms. Aaron, what we're trying to find out. I don't think it's apparent to the board, and Mr. Brashears can further elaborate on this, whether or not the victim or the victim was anyway associated to the incident. But I think as part of our investigation, the board is concerned with the attendance at the incident, whether or not the hotel was over capacity. And so there are some concerns by the agency whether or not there was a capacity limit that was surpassed by the hotel based on its certificate of occupancy or not necessarily. It's more so based on the license that they have that was granted to them by ABRA, because as you're aware, our license, the license that you receive from us, that determines what the occupancy is. Although you can have a certificate of occupancy for a larger number, but that number cannot exceed what's on the license. So we just need to get some clarification on that, and I'm hoping that Mr. Brashears maybe can bring some clarification, and then we'll have a response from the licensee regarding that issue. So again, this is a fact-finding hearing. The board is just gathering information. None of the witnesses will be under oath today. By law, at a fact-finding hearing, the board cannot order the licensee to take any specific action. Board members might ask the licensee to agree to take some action, but it's just a conversation that it's been requested. The board cannot order a licensee to take any specific action at a fact-finding hearing. So as I said before, we have made no decision, and so at the end of the hearing, what the board can do, it's either decide that no further action is necessary, or the board might forward this matter to the Office of Attorney General for them to determine whether or not there are any legal violations. Okay? So what we will start off is that we'll have Mr. Brashears. He can, I believe Mr. Brashears, that there's a report that was generated from the agency that Mr. Bashir, I'll ask him to go through his report. Then board members can ask questions of Mr. Bashir, and then on behalf of your client, Mr. Klein, you are welcome to ask questions of Mr. Bashir, and then if the licensee have any specific representation they want to make, then they'll have an opportunity to do that. Any questions before we start?
Mr. Chairman, I just have one comment that I think might facilitate clarity on this issue.
Go ahead, Mr. Klein.
And that is, unlike an on-premise license, like a restaurant or a tavern or a nightclub, the occupancy number on an ABC license is the number of rooms. So I would just, I want to point that out front because I could see where we can get down a road that would be confusing. So I just wanted to make that comment and then obviously defer to Mr. Bashir to give his report. But given the chair's introductory comments, it seemed there might be some confusion on that point, and I just wanted to make sure that that's clear.
And I'm hoping that the report that's written by Mr. Bashir can enlighten the board on that issue. And as
He will, and it's in his report. Thank you.
And I stated before, although it was a shooting incident that brought this to our attention, this hearing will not in no way focus on that incident because there's, at least it's my understanding that I'm not aware of a nexus between the incident and the hotel. It just so happened that the incident itself. So I was just letting you know, not that for you to be prepared to address the incident per se, because that's not why you're here today. You're not here because of the incident for you to tell us whether or not there was a violation occurred because of the incident. It was because of the incident that the agency became aware, and there's some confusion regarding the occupancy. And so that's what the purpose of this hearing is, to get some clarification on the occupancy and the licensing itself. All right, but thank you for that, Mr. Klein. And it appears that Mr. Bashir has disappeared, so let me wait hard. All right, Mr. Bashir, good morning, sir. Can you just tell us who you are, sir, and how you're familiar with this case?
Well, I'm an investigator here at ABRA, and basically I took the ABRA hotline call for the complaint that led me to visit the establishment.
So tell us about the hotline call. How is it that ABRA became aware of this incident? And once you became aware, what is it that the agency did, sir, please?
Yes, sir. So basically on Sunday, November 28th at approximately 2:20 a.m., I received a telephone ABRA hotline call from MPD stating that a shooting had occurred in the vicinity of the Shoreham Hotel. So I was asked to respond to the establishment. Upon responding, I spoke with an MPD sergeant who basically advised me that the shooting occurred off the premise of the establishment in the street. He further advised that the individual was there was an MPD presence due to the event that was happening at the establishment. While that was going on off premise in the street, an individual was found shot, as you stated earlier, through the buttocks into his leg. Based on that and the clothing the individual was wearing, MPD believed that the individual was not part of the event because it was a formal affair and everyone was dressed a particular way. So while there, I spoke with the director of loss prevention for the establishment, and he had worked with MPD to reveal any camera footage. Basically, he let me know that they had approximately 9 security personnel from the establishment on hand for the event, and another 25 from the promoter having the event. The issue with the question concerning the occupancy, it started with, based on what I observed on the certificate of occupancy, and as Mr. Klein alluded to, the certificate of occupancy gives an occupant load of 836. And since it's a hotel, it's basically a single occupant per room. So based on that information and what MPD had gotten, that there were approximately 1,200 people or more, MPD believed there could have been an issue with occupancy. As such, MPD and myself met with the management of the establishment, Mr. Roche Garland, and discussed the event. Basically, it was a formal affair. It was scheduled to go from 8 p.m. to 2 a.m. and originally had set up for 1,200 people. Throughout the night, the promoter brought a few more people in, but as things went on, Mr. Garland, Roche Garland, was there on scene, and they basically handled the issues that came up. I further spoke with the detective who was investigating the situation. The detective basically stated that the victim, he said he was in the area because he heard some things were going on, but the detective was not able to place the subject or the victim at the event or even on the property, nor could I through my investigation. As my investigation progressed, I spoke with the ABC manager. The ABC manager basically let me know that on the night of the event, they had approximately 10 bars, over 1,200 people. He wasn't sure the exact number. He thought it might have gotten as high as 2,500, but he showed me the establishment has some very large event spaces. And as I put in my report, the event spaces were placarded by the fire marshal. So 4 large event spaces, all of them listing an overall occupancy of 5,696. So I also looked at the hallways, routes of entrance and exit. And although the establishment, technically, if you look at the occupant load, yes, it was probably exceeded. But the fire marshal placarded the establishment in such a way that it could facilitate over 5,600 people. So I don't know, and it would be a good thing for, we have the management of the establishment. If there was a second certificate of occupancy, if these areas were added later, because what I found in our records, ABRA records, and what was provided to me was basically the certificate of occupancy with an occupant load of 836. So I don't believe the incident. Obviously, we can't draw a nexus, as you stated, between the individual being shot and the establishment. And I don't believe the occupancy that evening had any bearing on the incident. But at the end of the day, technically, the establishment was over what's on their occupant load.
Now, Mr. Bashir, their license that was granted to them by ABRA, it has an occupancy load. So what's on the license itself?
880.
Now, what does that mean? As an ABRA investigator, you have a license that an ABRA license that says the occupancy load is 880. So as an investigator, what does that mean to you?
Well, obviously I would look at the number of people and compare it to that number. And if it exceeded it, then I would assess a violation.
Thank you. Any questions by any board members? Yes, Mr. Short.
Thank you, Mr. Chairman. Still, good morning, Mr. Bashirs, or Investigator Bashirs. Investigator Bashirs, you stated that the application for this event to ABRA was for 880 people max. Is that correct?
No, sir.
What was the max that was given on the permit for this, or did they need a permit for this event?
No, sir. No, they did not. My understanding was the event was scheduled for approximately 1,200 people, and that at some point during the evening, the promoter basically took it upon himself to allow extra people in at the door. When that occurred, The atmosphere of the event somewhat changed. And Mr. Roche Garland had stated that, the establishment was on top of it, and they made a decision at that point, shut everything down, disrupt it, or keep an eye on it, let it play out. And bear in mind, a lot of the party goers to this event were also guests. So at that point, from what I got from the management, is that there weren't any issues with anything going on inside. So they just managed the event. And then afterward, if I remember correctly, Mr. Roche Garland had stated that this promoter would not be brought back.
Okay, now I do understand that answer, and thank you for that honest answer. I would like to ask you, basically, the room that was used for this event, what was the occupancy of that particular room? Just that room that was supposed to be for this event?
Well, there were actually 4 large event spaces utilized. There was also the main, it appeared part of the lobby. So all of those combined were over 5,600. The fire department had placarding in each of the rooms designating the space. And from what I understand, speaking with the ABC manager, they didn't get close to any of those occupancies in any of those rooms. And bear in mind, as the ABC manager had described to me, even though there were quite a few people there that night, people came and went. It wasn't a consistent number throughout the night. So the number they originally forecast for was 1,200. It may have gone substantially higher, but it may not have been all at one time.
Okay, so where did the issue of overcrowding come up? I mean, we're bored. We're just here to hear the facts because this is the fact finding. Where did the issue of overcrowding become an issue if all you say is true?
Well, MPD had concerns, and basically they believe that it could have whatever issue happened in the street, which, as I said, we can't say the establishment was involved in, but they believed that could have had the occupancy could have had an issue on those things.
So you, as the Arbor representative for that event or investigate that event, first of all, where did the complaint come from? Was it from the community? Was it from, or do you have any idea where the complaint came from?
The complaint to Abra came from MPD for a shooting in front of the establishment.
Okay, and again, just if you can clarify, I'm still not clear. How did the issue of overcrowding come up?
The issue of overcrowding came up when, based on my initial investigation, I was speaking with MPD, and we were told there were approximately 1,200 people slotted for the event. And I advised the MPD captain that looking at the certificate of occupancy and the ABC license, they were over that amount. So the MPD's concern was there some type of severe overcrowding issue that led to what occurred in the street?
Okay, I understand that a little better. And thank you again for your report. And I guess I would simply say this, that the security persons, you said there were 9 security from the hotel, correct?
Yes, sir.
And 25 from the promoter?
Yes, sir.
Okay, and as I normally would ask, I would imagine that the hotel security were trained persons who are licensed persons, or do you know?
From what I understand, speaking with the director of loss prevention, the staff is all trained. And if I remember correctly, the director of loss prevention is retired federal law enforcement. So they're well trained and we're on hand. They were the director and his assistant were on hand throughout the course of the event that evening. But that was another concern I had, whether or not the establishment was turned over to a promoter, but clearly the establishment had their security personnel and had 2 ABC managers on staff to manage the event.
as an Arbor investigator, with your experience and time on this at this agency, are there any recommendations that you would make to the hotel regarding incidents like this not happening again?
Well,
If you can.
I mean, if I were going to make a recommendation, I mean, clearly the fire department saw fit to grant a larger capacity than what Abra licensed. My only recommendation would be if there's something that bears weight on that, that a new CFO be submitted or something to reflect that the higher number. Because as I said, the fire department gave them, placarding for 5,600 people.
Thank you very much for your answers, Mr. Brashears. That's all I have of this witness, Mr. Chair.
Thank you, Mr. Short. Any other questions by any of the board members? Mr. Klein.
Yes, Investigator Brashears, thank you for a complete and thorough report. I do have a couple questions though. You said you looked at the certificate of occupancy and you determined that from the certificate of occupancy that the capacity in terms of number of people was limited to 836?
Well, that's what was on the certificate of occupancy. Well, the certificate of occupancy was basically listed as hotel 836 rooms.
So it's rooms that's mentioned on the certificate of occupancy.
Yes, sir.
And there isn't any limitation in terms of persons on the certificate of occupancy, is there?
Not that I recall. No, sir.
Okay. Will you have it attached? Do you have your report in front of you?
I do.
Will you take a look at Exhibit 3?
Yes, sir.
Okay. Does that refresh your recollection? You said not that I recall, but let's make sure that we have it clear in the record as to what
Yes, sir.
that says.
Yes, sir. Description of use, hotel, 836 rooms, restaurant, swimming pool, and parking garage.
Okay. So there's no mention of occupancy there. And as is the fire department's custom, they issued capacity placards for each of the rooms, correct?
Yes, sir.
All right. And based upon all the information that you discovered during the course of your investigation, the hotel for the rooms utilized was way under that capacity limitation, weren't they?
Yes, sir.
Okay. And the ABC license, which is attached to your report as Exhibit 2, it says capacity 8, it says license class hotel C capacity 880, correct?
Yes, sir.
All right. Now, if you know, isn't it true that the differentiation of capacity numbers with respect to hotels is for purpose of calculating the fee that's due to ABRA for the license?
I can't speak to that, sir. I'm not aware.
Okay, that's fair. That's fair enough. But there isn't any belief that more than 880 hotel rooms were being utilized, correct?
Correct.
All right. So it seems this whole issue concerning capacity was basically a misunderstanding, right?
Well, as I said, the occupant load listed on the C of O, and it does talk about rooms, but it does also say occupant load of 836 was exceeded. But at the end of the day, I'm sorry.
Okay, but you're using occupant load as being 836, which is the same number in the description of use as to the number of rooms.
Yes, yes, sir. And typically what I've found with certificates of occupancy in hotels, it's based on the number of rooms with single occupancy. So clearly, if every room had 2 occupants, it could be higher.
Well, if every room had 2 occupants and you also had event space, like this hotel or meeting rooms or other public facilities, it probably would be higher, wouldn't it?
Well, yes, sir. And that's why I suggested having some type of documents to cover that number so that, in the going forward, situations like this wouldn't happen.
Don't we have capacity placards on the wall approved by the fire department that cover that number?
We do, but the fire department did not license the establishment. Abra did.
For the sale of alcohol?
Yes, sir.
All right. And you don't know as to whether that number on the alcohol license relates to rooms or persons. Is that your position?
My understanding is what's on the ABC license is the capacity granted for the license by the ABC board.
And you believe that capacity to be number of persons rather than number of rooms?
On the ABC license, yes, I do. Yes, sir.
Okay. All right, I don't have any further questions. Thank you.
Any questions by any other board members? Okay, Mr. Klein, how does your client have a response? And as I stated before, there is an issue here that needs to be addressed. It should either be addressed by the agency or some other, because as Mr. Brashear stated, the Abra license stated what the capacity is for the facility.
No, I would ask that the board get with Mr. Musali in terms of the way these licenses have been treated for many, many years. The C of O is dated 2002, which means it's been in effect almost 20 years. In my experience, in my practice, in my practice, with respect to both DCRA and ABRA and the ABC board and its predecessors, is that hotels, with respect to licensing, are measured by rooms, not by occupant load. The C of O has the same number under occupant load as it has in the more precise description of 836 rooms. I hope that the ABC board is not telling us that we need to go back to DCRA and change the 20-year-old C of O, because I don't think that that's the authority of the board. And number two, I would ask the board to confer with ABRA as to its practice. This growth into policing occupancy that the board has undertaken is an outgrowth of a belief that the fire marshal wasn't doing it properly. But the fact of the matter is the numbers on these licenses are related to the amount of fees that are charged. That's where these numbers come from. If you go to the section concerning license fees, you will see that there is one license fee for hotels of 99 rooms or less, and a greater fee for, and I'll give you this section if I can find it. It's in the regs, and a greater fee for those that are more than 99. And that is the only reason that number appears on the license. So to suggest that somehow now has become a capacity number in terms of people who can occupy the premises, unless the regulations or the law is amended, that's just incorrect as a matter of law.
I guess, Mr. Klein, you stated that the certificate of occupancy is 20 years old. Has the facility changed over the 20 years, or has this been the same? I mean, is the certificate of occupancy that the hotel currently has, does that accurately reflect the occupancy of the hotel? I don't know. So because you stated it was 20 years ago, so there have been a lot of changes that have been made generally, not necessarily in this hotel, but in life. And so I'm asking, is the certificate of occupancy from 20 years ago, does that accurately reflect the occupancy of the hotel in 2022? I don't know. I'm asking.
My understanding is it does. I'll work backwards. The hotel has a parking garage. It is a swimming pool. It has a restaurant, and it has 836 rooms, and it's a hotel. So That's what's on the C of O. I don't have any knowledge that that's changed. And there's no reason to believe it's changed. I mean, the hotel is well known. I've been in it many times, and I suspect members of the board have been in it many times over the years. And I don't believe that there's been any change. I just think that what we're doing is we're bootstrapping a hotel room number into an occupant load, and that's just incorrect.
And I know that you're an attorney, Mr. Klein, and so I'm prefacing that. But isn't it true that as far as Abra is concerned, the occupancy on the Abra license is the occupancy that when the investigator goes to a facility that they look at? Isn't that true? I'm just saying generally, isn't that when an investigator go into a facility, the investigator asks for your Abra license and we make a determination. I know that this might be a policy issue that needs to be, as you're correct, that needs to be addressed by the director. But what I'm saying to you, based on your experience as an attorney, isn't it correct that when the investigator goes into a facility, that to determine the occupancy of a space, they look at the Abra license?
Depends on the type of Abra license. They certainly don't do that with respect to a Class A license. They don't do it with respect to a Class B license. And with respect to a hotel, the appropriate inquiry is the number of rooms, because that's the figure that's used on a hotel license. That's the figure that's been used in my almost 40 years of doing this. And if that's going to change, then okay, then there needs to be a rulemaking to change it. But to somehow all of a sudden we have a misunderstanding by an investigator where he believes in good faith, and I don't fault him for it. He believes that the number on the Abra license relates to number of people, when it relates to number of rooms and always has related to number of rooms, is no reason to visit anything upon this licensee. It's an issue that perhaps should be discussed by the board. If a change needs to be made, then it should be done by an appropriate rulemaking. But at this point, in my experience, and you asked me my experience, hotel licenses list the number of rooms, and the reason for that is the amount of the fee that's paid to the agency is based on the number of rooms. Now, it used to be that way with respect to CRs and CRs and CTs and CNs and DRs, DTs and DNs, until the board decided that it was going to enforce occupancy, and then those numbers took on a different meaning. But prior to that, those numbers were for purposes of measuring the amount of the fee that is paid to the agency. And I would, if we need to get Mr. Musali in here to talk about it, he's been doing this a very long time. I think he's very familiar with that history.
Mr. Chairman, may I ask a question?
I'll come to you, and I'll come to you, Mr. Short. Go ahead, Mr. Grandis.
Thank you. Mr. Klein, in my understanding then, the issue regarding occupancy for the hotel would be more of a fire marshal concern, because the rooms these ballrooms each have their own number of occupancy, which is unrelated to the number of hotel rooms. So the fire marshal would be the one to determine whether the occupancy had been exceeded, as opposed to the ABC license for a hotel.
Absolutely correct. And I think in this case, you saw that through the testimony concerning the occupancy placards that were approved by the fire marshal, which reflected the total occupancy in each of the various event spaces, and the fact that overall it was what was allowed among the 4 event spaces that were being used for this event exceeded 5,000. I forgot the exact number, but well above what was permitted in this space.
So, Mr. Klein, if I understand this, maybe it's already been stated for the record today, but has your client or you stated what, based on the fire marshal ruling on occupancy, what the occupancy of that facility would be?
Well, in terms of the, it's in the report, and in terms of the rooms that were used for the event, the overall occupancy of the 4 rooms was 5,696 people.
Okay, so based on those occupancy limits set by the fire marshal for each of these ballrooms, was that number exceeded that night?
No. The
Okay.
highest number that we have heard that may have been at the event at one time is about 2,500, which is, obviously less than half of that. So the answer to that is no, not even close. It's not even an issue. I think this all comes about because of confusion concerning what's on the ABC license.
So yes, so to follow up on that, so the confusion is that the license that the agency issues for a hotel uses the term occupancy, but it's defined by, I think, our regulations as the number of rooms, not the occupancy set by the fire marshal.
That's correct. And, to clarify that, I've tried to make the point, maybe not clearly, but historically, the numbers on ABC licenses were used to calculate fees. That's why they were there. And the C of O governed overall occupancy, and the fees that are charged for hotels are not based on the number of people, they're based on the number of rooms, which is why the number of rooms appears on the ABC license.
Okay, thank you. I want to thank you for giving us that information for this record. Thank you.
And thanks for your clarifying questions, because I think that might be very helpful.
Thank you, Mr. Grandis. Mr. Short.
Thank you very much, Mr. Chair. I would just like to state for the record, a hazardous condition is a hazardous condition, whether it was 20 years ago when it was established what the occupancy is, or today. A hazardous condition is a hazardous condition. Arbor is a fairly new, or one of the newest agencies of the district government. I say that for the record because, again, overcrowding is a hazardous condition, whether we want to talk about the number of people who are in rooms or the number of people who are at an event. And so to get around all of the convoluted legal conversation, apparently this was a hazardous condition seen by our investigator, seen
No,
by
sir.
the police officer.
That is not correct. I'm sorry to interrupt you.
Please let me
Mr. Klein, hold on, Mr. Short. Mr. Klein, please allow you'll get an opportunity to correct the record if you believe a correction is necessary. Go ahead, Mr. Short.
Thank you, Mr. Chairman. To give a perfect example, through my personal knowledge of public safety in the city, I can say to you on different occasions at hotels during inaugurals of presidents, this hotel before was cited for overcrowding, and no one asked about the number of rooms. No one asked about anything else. They said it was too hazardous for the president to stay there unless they reduced the numbers. And again, let's go back. If you want to go 20 years or you want to go today, a hazardous condition is a hazardous condition. We can haggle about numbers or who gives the numbers or what numbers they are, but apparently the investigator, apparently MPD, apparently other people who were there thought, or seeing what was going on at that time, came to the conclusion that it was hazardous, the number of people that were in that room, whether the promoter let them in, whether the hotel let them in. All of those things are, when it comes to an investigation, had someone got injured, hurt, or killed that night inside because of the overcrowding. So let's cut to the chase and let's get down to the point. If it was overcrowded, we could talk about numbers and who gives the numbers 20 years ago, who gives the numbers 20 minutes ago. If it was overcrowded and hazardous, then we need to alleviate those kind of conditions so that the city doesn't get a smudge on its record of safety. Thank you very much, Mr. Chair, and thank you for everyone who listened. Thank you.
Thank you, Mr. Short. Mr. Klein.
Yes. There is no evidence that there was any hazardous condition. The overall occupancy that was allowed by the fire marshal, Mr. Short, based upon the placards that are posted in the various rooms, is 5,000 696. The only discussion concerning any number of people that were in there at most was 2,500, which is less than half of that. And the investigator testified that there were about 1,200. It's only through our client where they say, yeah, at the most there was 2,500, which is less than half of the allowed number by the fire marshal, the agency with which you used to work. They allowed 5,696, and there were no more than 2,500 people in there, according to the testimony. As I tried to state at the beginning, obviously not very clearly because it seems to be still misunderstood, this is all based on a misunderstanding as to the number printed on the ABRA license, which relates to the number of rooms, not the number of bodies. The number of bodies allowed is established by the placards that are posted on the wall and approved by the fire marshal. So there was no hazardous condition, and there's been no testimony adduced during this fact-finding hearing that any hazardous condition existed.
Thank you, Mr. Klein. Any other questions by any other board members? Any further representation you need to make, Mr. Klein, before I bring this hearing to closure?
No, I mean, I hope we can get some clarity on this and get this cleared up. I mean, in looking at the report, I mean, this is the Omnishoreum Hotel, and I don't say that just by its reputation. I go to the last page when I get these cases, and I always look at the investigative history. You will see that it's clear. With respect to this event, you also see in the report, and we stand by this, that the hotel does not intend to work with this promoter in the future. Although not before the board, because the board has indicated this was questions all about occupancy, they were concerned about some things that went on and tried to wind things down, and at one point even considered shutting the event down, but they thought that that would create more problems than it would solve. So I think overall, the hotel acted responsibly and prudently. It is unfortunate that there are so many guns in our city right now, and it's unfortunate that there's so much violence. The only connection to this establishment is the proximity to of the incident, based on what we know. And in terms of the occupancy issue, we're certainly willing to continue to work with the board and the agency to make sure that there's clarity and everybody understands. I mean, perhaps the licenses need to be reformatted with respect to hotels, so investigators will know that the number on those ABC licenses relates to the number of rooms and not the number of physical bodies that are allowed in the establishment. Thank you.
Thank you, Mr. Klein. Thank you, Mr. Bashir. I know Mr. Roach Garland, you didn't speak today. Thank you, Mr. Klein. As I stated, this is a fact-finding hearing, and the board is gathering facts. And the next step is for us we're going to take this matter under advisement. The options that the board has, it's no further action. Well, probably in this particular case, we have 3 decisions have to be made, either no further action, whether or not we'll send this matter to the Office of Attorney General because it's determined that there is a violation, or whether or not the board or the agency needs to look at its licensing. What does it mean for a hotel if their license states that the occupancy is 800? What does that mean? All right, so that we will make a decision and inform you of what our decision is. Thank you very much.
Thank you.
Good day. All right, the next case in our calendar is the fact-finding hearing for the Springs, license number 120472. Ms. Foshman, can you please elevate the rights of the participants in this case, please?
Please stand by. Anna Valero, your rights have been elevated. I'm still here. I'm looking for. There are no members of the ANC. Oh, Shireen Joseph, your rights have been elevated. Cecily Mendy, your rights have been elevated. That is all, Mr. Chair.
Thank you. Hold on 1 minute.
Mr. Chairman, we're expecting a couple members from the downtown bid who are getting on right now, is my understanding.
All right, so can they identify themselves, and I'll make sure that their rights are elevated. So,
Great.
all right, so let us know who they are. And I was just myself looking at the attendees list to see who else is at least has signed up to be here today.
Latasha Steiger, your rights have been elevated.
Looking for Mr. Guerin. I think it's the last one that we're looking for.
I believe Jaren's jumping on to Cecily's video.
Great.
Cecily Mendy.
Perfect.
He's just coming out of another meeting.
Is this everyone? I mean, do we have representatives? I think we have a representative from the bid. Are there any representatives from the ANC? Is there anyone from the ANC who wish to be
Brian Romanowski, your rights have been elevated.
All right, thank you.
Hi, Chair Anderson. This is Shireen Joseph, Chair of ANC2F. I am present.
Okay, thank you. All right, thank you. All right. Good morning, everyone. This is the fact finding hearing. If you have a camera, please, your rights have been elevated, and so can you please let us see who we are talking to today, and I'm going to have everyone identify themselves for the record, and I'll start with you, Mr. Klein, since you are the designated representative of the licensee. So, Mr. Klein, I'll have you identify yourself for the record start with you by spelling and stating your name for the record, please.
Great. Thank you, Mr. Chair. Good morning again, Mr. Chair, members of the board. Andrew Klein, ANDRAW, last name Klein, KLINE.
Good morning, Mr. Klein. Who is your client?
Ms. Valera, will you identify yourself, please?
Yes, sir. Good morning, Mr. Anderson. Chairman, my name is Anna Valero, ANNA, last name V as in Victor, ALERO, and I'm the licensee.
Good morning. Let's go
morning.
to the ANC. Let's have the ANC represent themselves, please.
Hi, Chair Anderson. My name is Shireen Joseph. That's SHERENE. My last name is Joseph, JOSEPH, and I'm Chair of ANC2F. I'm also joined by my colleague, Commissioner Romanowski.
Mr. Romanowski, can you please spell and state your name for the record, please?
Yes. Hi, good afternoon. I'm Brian Romanowski. It's BRIAN, and my last name is Romanowski, ROMANOWSKI, and I am the ANC Commissioner for ANC2F01, and I chair our Alcohol Policy Committee.
Good morning. Do we have someone from the bid? We have no representative from the bid?
Hi, good morning. My name is Cicely Mendy. I am the Franklin Park Manager with the Downtown DC bid. My name is spelled CECILY. My last name is MENDIE. And
I'm sorry, you broke up, Miss Bid. Again, I'm sorry, you broke up, Miss Mendez.
I'm sorry.
Miss Mendez, you are breaking up. You're breaking up. So who are you again, ma'am? What?
I am the Franklin Park Manager with Downtown DC.
Thank you.
So I'm Latasha Steiger, LATAFHA, last name STIGER. I work with events and partnerships for Downtown DC bid.
Okay. Good morning. Has everyone been identified? All right.
Sir, we are still waiting for Jaron Price, our acting CEO. Is that okay?
Yes, you can, once that person is available, let us know and we'll elevate his rights.
Thank you so much.
All right, thank you. All right, this is originally this is a fact-finding hearing. A license was requested by Ms. Valera, applied for retailer's Class CT license with an entertainment endorsement and a summer garden with 20,000 seats for Franklin Park, which is a National Park Service land put under supervision of the district. On our calendar today was a request from Miss Valera. She had requested a one-day temporary license, and it was also the agency was informed overnight that the licensee wanted to change the request from a one-day temporary license to a one-day substantial change for her license at, I think, Krakenax, I believe that's the name of the establishment. The board this morning decided that we were not going to honor the request to make the change because the change was not the request that was made was not timely. As you're aware, all requests for substantial change or one day, there is a specific timeline for those requests to be made. And the request that came into the agency overnight. And so therefore, because it was not timely made, we are not gonna consider that request on timeliness. And so I just need to get some clarification. Then, Ms. Valera, are you still pursuing a temporary license for this event? I'm sorry, are you still pursuing your temporary license? Because we need to get some, even the board has not made a determination on that request. And so since we're having a fact-finding hearing today, the board intends to ask some questions regarding the one-day temporary license that you had requested for April 2nd, 2022 for 500 attendees.
If I may, I'd just like to give an overview and then I'll turn it over to Ms. Valero and others to discuss the specifics.
Go ahead.
Franklin Park. It has been, unfortunately, an underused, underutilized facility in the District of Columbia for as long as I can remember. And when I started practicing law, more years than I want to say. My office was at 15th and K, and Franklin Park was a scary place. And it's continued for the most part, unfortunately, to be somewhat of a scary place. The objective here, which is the goal of the goal of the bid, who you'll hear from, and also my client, is to activate the park. A lot of money has been spent refurbishing it, remodeling it, making it nicer. But physical improvements alone, as we've learned over many years and countless attempts to make it an attractive place, aren't going to get it done. It needs to be activated. It needs to be programmed. There need to be reasons why people will come there and spend time in this wonderful tract of large land in downtown DC. And I know the bid very much wants that, and as I said, you'll hear from them. And my client very much wants the opportunity to assist them with that. We've been at this for some time. We have a license application pending. I urged the director to go ahead with placarding so we could move this forward. He advised that you wanted to have a fact-finding hearing before it could be placarded. But all of it has put us behind the 8 ball, and we've been working with the agency to get this space activated as quickly as possible, which is the reason for the temporary requests. And there's a thought late to change it to a 1-day substantial change. It was thought that that would better facilitate what was intended. But overall, that's the goal. The goal is, let's make this a place that's not just pretty, but a place that people have a reason to come to. And it's the goal of the bid and Ms. Valera's company to turn this park into that place. And that's why we're here today.
I think, Mr. Klein, I think you might have forgotten what I stated. The purpose of the fact-finding hearing is because Ms. Valera, the Springs, applied for a permanent retailer Class C Tavern with an entertainment endorsement and summer garden with 20,000 seats for Franklin Park.
Yeah.
Okay. So a permanent license has been asking for 20,000 seats. Okay. So the board wanted to get more information because this is more so unique because this is a facility that's owned by the federal government, by the National Park Service. So we're trying to get some clarification whether or not this licensee can even apply to have a license on the National Park Service on a National Park Service land. And so prior to the board making a decision whether or not to even placard this decision to allow the community for input, we need to find out whether or not this licensee has the legal capacity to even apply for a license to serve alcohol in this area. And even if they have that capacity, the 20,000, is that even a feasible number for us to approve for 20,000? So we're just gathering facts for us to see whether or not, if we have enough information, then of course the board will vote to allow the process to go through, meaning that if we have enough information, then the board could vote to say it can be placarded for the community to have community input. But it doesn't make sense for us to have the community input on the license if this licensee is not authorized to have a license on this facility. And so after the request was made for the permanent license, the licensee also wanted to have an event on April 2nd and a 1-day substantial change. I'm sorry, a temporary license was timely filed for this area. And the board was willing to move forward on that issue. However, overnight, the licensee reached out to the agency and said, oh, by the way, I'm no longer requesting a 1-day substantial change. I'm sorry, a 1-day temporary license. I now want to convert this to a 1-day substantial change so I can use my current license. which is separate and independent. I want to use my separate license on this facility. The board, on timeliness, decided that we're not going to consider that request because it was untimely made. Not that it was not meritorious, but just it was untimely made. And so, because we have this fact finding hearing today, we decided that since all the parties are here, let's get some clarification from the licensee. Now that we have now, based on timeliness, we are not going to consider the substantial change. Does she want to move forward with the original timely filed license for a temporary license? Yeah.
Mr. Chairman, thank you for that. I appreciate that. But for the record, the request for to change it to a one-day substantial change was made last Tuesday, 8 days ago. It was not made overnight. And we've been pushing the agency to get it before you. I'm just, for the record, I don't want it to sound like we came in last night and made this request. It was made 8 days ago. But be that as it may, I appreciate the setup that you've given, and I turn it over to the others to address the other issue.
No, but Mr. Klein, that is if the board made the decision not to move forward with that application on timeliness because it was untimely filed. So if you're saying that it was filed timely, then that's a different analysis because the board did not make any type of substantive decision on the one-day substantial change. The decision was that because it was not timely filed, we would not. And the public agenda that the board has state there is a it's a temporary license. That is what is on our public agenda. There is nothing on our public agenda for a one-day substantial change. Okay, so I just wanted to say that.
I just want to clarify from our standpoint. Nobody ran in here yesterday and expected your agency to do something within 24 hours. The request was made last week.
So,
excuse me, Mr. Anderson, excuse me, I apologize for interrupting. I just want to let you know that Mr. Jaron Price is on the call now.
Miss Foshman, can you elevate the rights of Mr. John Price?
Jaron Price.
Jaron Price, please.
This has been accomplished.
Thank you. Mr. Price, can you please spell and state your name for the record and your relationship, sir?
Yes, sure thing. And I apologize. It's saying that my settings are not set to allow video. I'm going to figure that out in a second. But my name is Jaron Price. Jaron is spelled Gerren. Last name Price, Price. And I am the acting president and CEO of the Downtown DC Business Improvement District.
All right. Thank you, sir. Where is Ms. Valero? Do we say Ms. Valero?
I'm still here.
Okay, all right. Now, all right, so do you still want to move forward with the temporary, the license for temporary, one-day for temporary license to have this event on April 2nd?
And if you can, just for my own clarification, I do want to move forward with the temporary license. I think one piece of clarification is just which license is that. We've been asked by ABRA to submit approximately 4 or 5 different licenses, which we have done over the course of the last 2 months. And so I just want to be clear what was brought to the board.
All right, Ms. Valero.
We were asked more.
Ms. Valero, hold on. You're in a bad area. I don't know. I'm having some problem because your connection is poor. Okay. All right. This is what's on our calendar today. Let me know when you're ready, ma'am.
Is this better from an audio standpoint?
All right, yes, ma'am. All right. This is what I'm asking you about. You applied for a one-day license class G to have the Cherry Blossom Festival on April 2nd, 2022 Hours of the event from 12 p.m. to 10 p.m. Alcohol service from 12 p.m. to 10 p.m. And you're asking for 500 attendees, 10 security guards. That is what I'm asking you about, ma'am. You requested a one-day license class G for that event on April 2nd. Are you clear?
Yes, and yes, we are asking for that license.
And can you provide us some background information on what is it you're requesting for that license, so we can make a decision independently on that issue?
Yes, sir. Very, very succinctly, this is an event that is being done in conjunction with the Downtown DC Business Improvement District and the National Cherry Blossom Festival. They have asked for us to produce an event for the Springs, which is the licensee that will eventually be in the Cafe Pavilion space in Franklin Park. We're working in conjunction with them to produce this event that is on April 2nd. It is an event from 2 to 6, is a very family-focused event taking place in the park with lawn games and children's performers and very immersive Instagram-esque activations around cherry blossom with live music in the park. And then from 7 to 10, it will be a similar type of event, but much more focused in one tent that is taking place on the west lawn of the park, and it will be a DJ type of event with very, again, similar uplighting of the Instagram activations, and that will end by 10.
All right, now you're asking for, you want to serve alcohol, so where is it that, and at least the license that you requested, you're asking for alcohol sales from 12 p.m. to 10 p.m. So where is there a bar set up? So where is it that specifically on the grounds would alcohol be served?
That will be taking place in the tent area only on the west lawn of Franklin Park.
And what are the
So underneath the tent.
And
that's a tent that has been permitted from DCRA.
And so you'd be serving alcohol in this tent area between 12 and 10 p.m. in the night. Is that correct?
Correct. From when the event starts at 2 until 10 o'clock.
Miss, you're out. So therefore, you're amending your application to us. It says that hours of event 12 p.m. to 10 p.m. Alcohol sales from 12 p.m. to 10 p.m. So what time are you asking the agency to approve? What are the hours of the event, and what are the hours of the alcohol sales that you are requesting?
We are requesting that which is in the application. We have found from a best practice standpoint with ABRA to always ask for a few hours prior to the event and to end it at the exact event time.
So you're asking for alcohol sales from 12 p.m. to 10 p.m.
Yes, and can give you a whole list of reasons why that's best practice, but if you have a VIP that walks in that suddenly wants a beer at 1:30, far be it, it puts the licensee in a tough position with the client. And so we always ask for it right before the event starts.
And what's the expected attendance at this event? What's the expected?
We expect there to be about 500 attendees, somewhere between about 500 attendees for the event.
And can I leave the tent with alcohol?
The intention is to have the alcohol limited to the tent area. So the west lawn of Franklin Park is a very delineated space within the park. And so we have the intention of having the area right outside of the tent. And so alcohol service will only be in the tent. And then there is a pathway that is hardscaped in the park. And that will be the point where people can enjoy alcohol on that west lawn so that people can be outside of the tent. Given that it's a park, we're looking to activate the park, the grassy areas of the park itself. but not to go throughout the rest of the park for this
So
event.
what type of security do you have to manage to ensure that folks are not walking all over the park with drinking, with alcohol?
Yeah, we have both third-party security, and in addition, the Downtown DC bid has 11 trained ambassadors who work in the park already. And so part of the security briefing on the day of the event is letting people know, along with signage, that you can't take alcohol off the west lawn, and that hardscaped pathway will be patrolled by security and ambassadors.
So what measures do you have in place to prevent underage drinking?
Anyone who is consuming alcohol will need to be ID checked at the tent and receive a wristband. Only those who are wristbanded over the age of 21 will be able to consume alcohol. We reserve the right to, just like in any brick and mortar facility, to question the age and ask to recard anyone who does not have a wristband on. And then the alcohol serving staff are all tips trained, and they also will be ID checking if they don't see someone with a wristband at the service areas.
Now, has this event been permitted by the Park Service and the district?
Yes, so as you noted before, this is a really unique space in the district in that it is technically National Park Service land. National Parks gave essentially the right to DC government to spend $18 million renovating the park. They've done a beautiful job. National Park Service has a cooperative management agreement with the Downtown DC bid in order to manage the operations of the park. This is an event that is being, as part of that management agreement, they permit Downtown DC bid in order to select to serve alcohol in the park. The Downtown DC bid has, and you should see submitted along with the application, a letter that has provided us with has requested us to provide that service for this event on April 2nd.
Now, our files also show that a previous permit expired expires in March. This event is for April. So do you have a updated permit?
Yes, and that has already been submitted to the Abra office and was submitted earlier this week.
And do you know the date of this permit from when it runs from what period? Are you aware?
They run, and this would be a question for the bid. I believe they run on 3-month turns, and so it starts April 1st and runs for the consecutive 3 months.
And does this specific permit cover this event?
Yes, it does. The Downtown DC bid has a master calendar of events that are covered by that. Essentially, it's what we in the district would consider a special event permit. It's a master special event permit for events happening in the park, and this event on April 2nd is included as part of that master calendar.
Miss Tiger, it's Steiger or Stigger? Which one is it?
Steiger.
Miss Steiger, I've been asking Miss Valeris some questions, and I see you shaking your head. So, but I want the record. So, therefore, the questions I'm going to ask you, can you tell us that? Tell us about the permit, then, please, since I see you've been shaking your head. So, and tell me who you are, ma'am, and speak about the permit, please.
Yes, I serve as partnerships and events associate, mainly for Franklin Park. So in conjunction with Anna and her team, I do events for the park. And so I am the one who actually submits the permit to National Park Service and receives the permit from National Park Service. And so I submitted this permit months ago, and we have the signed permit for Q3 of this year in hand.
What does that mean, ma'am? Q3, what?
Sorry, sorry, third quarter. So the permit begins on April 1st and goes through for the next 3 months, the end of June.
And so why is it just every quarter? Why is it not more long term? And how is that determined?
So we have what is called a work plan that is submitted to National Park Service. So that is for the full entire year, so from October to the end of September. But then every quarter, since there are possibly updates, we submit any updates to National Park Service, and so that's why there is a separate permit for each quarter of our cycle.
And so does the permit cover this specific event on April 2nd?
Yes, it does, sir.
All right. All right. Any questions by the board members? Remember this, I know that this fact finding hearing is two phases. The first set of questions that we're asking are on the temporary license for the event on April 2nd. So do any questions by any board members who want to ask questions about the request for the temporary license on April 2nd? All right. All right, there are none. And any questions that maybe the ANC or anyone else wants to ask Ms. Valera about this event on April 2nd? All right. Okay, I don't have any further questions I don't have any other questions for this event on April 2nd. So the board will make a determination, and when we will vote on the record when we do our temporary and one day when we later on today, when we vote on the record for our temporary and one-day substantial change calendar, then we will make a decision whether or not we're going to grant the
Mr. Chair,
requested license.
Mr. Chair.
Yes, Mr. Short. Yes, Mr. Short.
I did just have one question, and that would be about the sanitation, restrooms, toilets. What is the capacity of the toilets in the park at this particular time with the renovations? Can anyone answer that?
Yes, I can if no one else would like to. There are permanent toilet facilities that were put into the park as part of the renovation. And so there is a building that was built on the park. Half of it is the cafe pavilion, part of the pavilion, and the other half are public restrooms. Those public restrooms are able to accommodate the 500 guests who are coming to this event, especially over the time period. As this is an outdoor festival, it will be people coming in not all at once, but people coming in over the course of the day. Those restrooms are maintained by the Downtown DC BID ambassadors in the maintenance crew, and that was all reviewed from. And that building also has hot water and sanitation that will be utilized.
Thank you. Can I finish?
Mr. Short, I was going to ask either Ms. Steiger or Ms. Mendy to be more specific since they're from the BID, and so I believe they can give you a better answer if one's available. That's the only reason I cut it, Mr. Short.
There are 4 toilets on site in the facility that Ms. Valera was referencing.
And in terms of cleaning, we actually clean them as used. So they're not, it's not something that we come by every 2 or 3 hours to clean. They are constantly cleaned. We have somebody that is actually stationed there. So as patrons come in and out and use the space, the staff go right in and clean. We have, used that space now for multiple events that have happened in the park with far more than 500 individuals. And we've been able to, keep the space well maintained and, available for anybody all day long.
And that was Ms. Mendy speaking, is that correct?
Correct. I'm sorry. Yes, that was.
Let me ask everyone, when you speak, please identify yourself. We have a court reporter, so just identify yourself so the record will reflect who is speaking. Okay. I'm sorry. Go ahead, Mr. Short.
I do. Thank you very much. So, again, this is to the BID, I guess, to Ms. Mendy and Ms. Steiger or Mr. and Price. There are 4 toilet bowls, correct, for the whole park?
Mr. Short, I'm going to jump in.
Wait a minute, please forgive me. Mr. Chair, can we have some order? Can I please just ask the question, please? Thank you.
But I think there's some relevant information.
Thank you, Mr. Klein.
Hold on, Mr. Klein. Hold on, please, Mr. Klein. I know that you represent, Mr. Klein, it's my understanding you represent the Sprigs. we're asking the questions that are being asked. I know Ms. Valera did respond as to the best of her recollection. And we have representatives from the bid here. And so they have made themselves known. I've asked a lot of questions of Ms. Valera. And when I'm looking at the screen, I see that Ms. Steiger from the bid, she's been shaking her head and saying that she agrees with Ms. Valera. And so one of the things that I have been doing, because as you know, it's best to go to the source rather than um, a third-hand information. And so since the bid is here, I would give you an opportunity to speak, Mr. Klein, but here it is. Please allow, Mr. Short is asking some questions specifically to the bid, and let the representative, I will give you an opportunity to speak once one of the representatives from the bid has responded to Mr. Short's question. All right, go ahead. What's the
Thank you, Mr. Chair.
Okay, thank you, Mr. Chair. Again, this is to Mindy, Steiger, and Price. The pavilion has toilet facilities with hot and cold running water. That sounds great. How many toilet bowls are in the facility, and how many hand washing basins are in that facility?
Hey, this is Jaron Price. I'm sorry, I've been having some connectivity issues, so I hope you all are able to hear me okay.
Yes, sir.
Happy to answer that question, Mr. Short. So there are 4 toilet bowls that are in that pavilion space for the public to use. And then in terms of wash basins, as you're sort of entering the space and sort of exiting from where the toilets are lined up, there are actually 2 sink facilities that are available for people to use that contain a total of 4 faucets. So it's really 4 stations total for people to wash hands. And I apologize, actually, as I'm thinking about this, it's actually a total of 6 toilets because we have 2 that are ADA accessible. So please forgive me. It's 4 standard, 2 ADA, so 6 total toilet bowls that are available in that pavilion space.
Okay, again, thank you very much, Mr. Price. Again, so for the record, there'll be 500 guests on this particular permit if it's granted, correct?
That's correct.
And between 6 toilets and 4 hand bowls, you think that would be adequate, or is that too many or too less, or?
Yeah, I'm confident it'll be adequate. I'll tell you, we've held a number of events in this park since the mayor cut the ribbon back on September 24th of last year. And we've had concert events and sort of large scale happenings in the space where we've had close to 1,000, even 1,200 or more people who are frequenting the event, and the bathrooms were perfectly fine in terms of the accessibility. No major challenges as far as use. We keep them stocked, we keep them sanitized and clean. We've never experienced an issue even with our largest crowds in the space.
Okay, I thank you for that testimony, because again, public safety, a part of that is sanitation.
Absolutely.
I as a board member would ask that question simply for the fact that I enjoy parks, and I have enjoyed Franklin Park, at least before it became an eyesore. And I've been in Washington, D.C. for 75 years. A lot of people don't like me to keep saying that, but I think it's relevant to what we're saying. And
Absolutely.
And in my 75 years, I've seen the turnover in that park. And I am, as a proud resident of the District of Columbia, glad that it has been renovated, and that the bid is taking their responsibilities very seriously. And I commend you and the bid for that. But again, for the record, there are 4 or 6 toilet bowls and 4 hand washing bowls for the facility.
That is absolutely correct, Mr. Short.
What is the maximum number of people that you think that the park could handle with those facilities, with toilets and hand bowls? What is the maximum you think that the park could support?
The maximum number of, I apologize, I think I missed the last part of your question. Could you say it one more time?
Patrons or visitors at an event at the park, what do you think, or what knowledge do you have, or what expertise do you have to give any testimony on the numbers of people that the park could support with toiletry, hand washing, toilets and et cetera, those kinds of things. And also, one last caveat to that, is there going to be any first aid or any water provided in the park for patrons who are visiting?
Sure, I'll defer on the portion about the first aid and defer to the team running the actual event. I would just say with respect to the restroom capacity question, one of the things that we've done since we've opened the park, we're really conscious of sort of when we have large numbers of people coming for events. Thus far, we've been able to accommodate, the numbers that we've had. I mentioned the 1,200 person concert series that we had at one point, and the restroom facilities were just fine. But if we were ever to have a larger event, we were anticipating larger crowds, we could certainly engage and bring on some outside additional toilets. And so that's something that we would certainly think about and consider. I don't believe it will be necessary for this particular event, but that is certainly something we would do in the future. So if we were to have, say double attendance, we may want to provide some additional toilets on the premises. But for right now, I think we've been able to accommodate folks just fine.
Thank you, Mr. Price. Now, one last question on this issue. The DC regulations, which you are part of a DC agency, I take it, or the bid, have you checked with the district government and found out what the regulations say about numbers of people to numbers of toilets? Has anyone in the bid checked that out officially from the district government?
I don't have the official numbers with me. We are not a government agency, so I do want to just clarify. The Downtown DC Business Improvement District is a private nonprofit. We're a 501c6 organization, but that is certainly something we will get access to.
Okay, and I thank you. Now, just simply say to you, I have worked with bids before, even before I became a board member here with ABC. So I know a lot about the bids and what wonderful work they do in our communities. And I want to thank you and the bid for coming and testifying before us today. And if you would get that information from the district government about the numbers of people and the numbers of toilets that the regulations of the District of Columbia have put in place, I would appreciate you, if you would, and you don't have to, turn that information over to Arbor or the board. Thank you very much. Thank you,
Sure,
Mr. Chair. That's all I have of this witness. Thank you.
Thank you, Mr. Short. I'm going to come back to Mr. Klein. Any other board member want to ask any final issues regarding, any final questions regarding the temporary event? Yes, Ms. Joseph.
Thanks, Chair Anderson. I'm so sorry. This is Shireen Joseph speaking from ANC 2F. I did have a question, and I wanted to just clarify around entertainment being provided this weekend at Saturday's event. What are the types of entertainment? Actually, Mr. Price's comment about the concert series was what reminded me about this, because the ANC did receive a couple of noise complaints in response to the concert series, especially given that the timing often indicated that it would be until 10 p.m., but music went until 10:30, and residents were pretty frustrated after that 8 p.m. time mark of having constant music. So curious as to the entertainment that's going to be presented this Saturday.
This is Cicely Mendy. So yes, thank you for that question. So we actually are, obviously, we were cognizant of the community complaints about the noise during the concert series, and to make sure that that would not happen again, we have entertainment now that is going to and will be done by 8 p.m. It's not going to be to the same voltage as the concert series was. We're actually going to be using the Department of Parks and Recreation Showmobile, and we're going to have a cover band that will be performing, but we will end all of the music in the park by 8 p.m. In fact, it will be done prior to that.
Okay, great. And then one more question. So entertainment will end by 8 p.m., but will there be, for example, any announcements or any broadcasting of any kind post that 8 p.m. timeframe?
If there is any, we don't plan to have any broadcasting. I'm sorry, we will have a DJ in the tent until 10 o'clock, but that will not be, audible sound as it was with the, with the concert series.
Thank you.
Sure.
Mr. Klein, you'll have the last word on this is only regarding the temporary license.
Yeah, just two things. One is, and I tried to get this in before, Ms. Valero has been in contact with the health department concerning the requirements that exist for all of these events. So, I wanted to put that on the record, that no one's ignoring the health department. That's been done. That will continue to be done. So I don't want any board member to be concerned about that issue. It's not being ignored, it's being addressed, and it's being addressed with the agency that has jurisdiction over that issue. Second is, given the history of this thing, and it's not really on the record at this point, but we would respectfully request that the board reconsider the denial of the one-day substantial change. We believe it was timely filed. Ms. Valero has been working with the agency for a month and started with the festival license, and then was told to change that. And we've been pushing to try to get this before you. As I stated earlier, this was not filed yesterday. And the only difference is, from what we know, is it will allow her, under her current license, to start ordering product and stockpiling for the weekend event, which gets to be more difficult with the one day. So under the circumstances, we would respectfully request that denial be reconsidered. If it's reconsidered and it's determined that it shouldn't be granted, then of course we would want the board and would request the board to grant the temporary. But I mean, she's worked with licensing and acted in good faith and has been at this not since yesterday, but for several weeks, and it's frankly been quite frustrating.
Mr. Klein, the board, before making a decision, the board will ask the agency to present to us the documents. As I stated before, on our public record, the only license that's on our public record for today is the temporary license. The board has not seen any documentation for a substantial change. Orally, the board was informed that yesterday information was provided to the agency to ask for a one-day substantial change. But whatever decision is going to be made, the decision, whether or not it's a one-day substantial change or a temporary license, we're going to make a decision today. The license will be, if we approve it, the license will be granted. If this decision, because we have to vote publicly, so depending on how our schedule goes, we will vote publicly on the record today. And so if it's a yes for the temporary license, then Ms. Valera can pick up the temporary license today. If it's a yes. So I'm not quite sure what's the difference, but whatever decision will be made, the decision will be made on the record today on those licenses. So if as you stated, the license was publicly, if it was timely made with the agency, we will ask the agency to provide the board with that application and to make sure that a complete application for one-day substantial change, as you state, was provided to the agency 8 days ago. Now, I don't know if a complete application was provided 8 days ago. I do not know when, since I'm not looking at the application, I don't know when the temporary license application came in. I don't know. But I'm just trying to figure out, and which wouldn't make sense, Mr. Klein, why would the licensee apply for a temporary license and a one-day substantial substantial change for the same event that's supposed to be on April 2nd? But as I said before, before we make a decision, the board had made a decision this morning to say that because it was not provided to us timely, that we were not going to consider. So it wasn't that we said we did not deny the license. We're just saying that because, as far as we were told, the timing was not provided to the agency timely, so the board does not consider license requests from anyone if it's not timely made. And so that's just the position. All right, but anyway.
Ms. Valero can address that in terms of why that was done.
Mr. Chairman?
Yes, Mr. Grandis.
I'm sorry, and I know this is irregular because you're trying to wrap this up, but there is somewhat confusion on this point, and I think the attorney did try to answer, but may we ask the attorney, can we hear from Ms. Valero if she's the one who turned it in, on what day she submitted it? Can we do that? Because I think it'd be helpful.
Sure, you can go ahead and tell us what
Mr.
it is was sent to the, what was provided to the agency.
Mr. Klein, may we talk directly to your client,
Absolutely. Yes, please.
Mr. Valera, thank you. Can you answer that question for us?
Sure.
you.
You know, there's quite a history on this April 2nd event, and really this started back in December, beginning of January of this year, when we were working with the bid in order to do a multi-week activation in the park for the winter. And we met with ABRA at the time because we said we are in the process of, we had two questions. One, what's the best way for us to do a license for this temporary pop-up? Well, two, we submit our formal long-term application for the Springs. During that meeting, the bid and ABRA and Mr. Klein and I had, what we were recommended from ABRA was to put in a full license application with the outside space being a summer, endorsed as a summer garden. So the general space of the park as a summer garden, using just whatever the calculation was that, you know, it would typically be for bodies in the size of, you know, per square foot. And then at the same time, it was decided that the best way for multi-week activation was with a pop-up license that was regulation created under COVID rules. We went through the process to apply for that license, and in doing so, we realized that one of the requests that was made for that license application is a certificate of occupancy. Given the certificate of occupancy for the space, given the very interesting, you know, federal local jurisdiction happening here, that it was determined there wasn't a certificate of occupancy ever created for the park space, that the park doesn't actually have a certificate of occupancy. And so we were going back and forth with with ABRA and the and DCRA and the Office of Nightlife and Culture on what's the best path forward, knowing that there wasn't the certificate of occupancy. Was there something that could stand in the place for it? And this is where it's all gotten very jammed up. We were then, from that point, without the certificate of occupancy, advised to submit a festival license. However, one of the requirements so we submitted a festival license. However, one of the requirements was for a festival license is also a certificate of occupancy. So we were sort of back to square one after submitting that. The request was also made in order to use something in lieu of something like an occupancy placard in lieu of the certificate of occupancy, knowing that they essentially, you know, per the earlier case, serve the same purpose of how many humans can you have in a space. There was, you know, we were essentially told at that point, we can't do that. However, what you should do is you should submit a one-day license. We completed the one-day license. We submitted that in a timely manner, and then we were requested to, instead of doing the typical one-day license, to use a substantial change on an existing license, because ABRA felt strongly that there being a tie to an existing license, as opposed to a one-off license, put more of a liability on me as the licensee in order to ensure that this event was successful. And so we have, at this point, I've done every license application that ABRA has. We were, and so given that we were asked to make that change on the substantial, and at this point, given where we are in terms of timing, for those of you who aren't ordering booze on a regular basis, a lot of the distributors have cut back their delivery schedules because of COVID and because of the issues with finding drivers. And so a lot of them have cut back on their Thursday, Friday deliveries. A lot of them no longer deliver on, most of them, none of them deliver on Saturday anymore. Most of them have stopped doing deliveries on Friday as well. And so I'm also now just getting pushed into a really tough delivery schedule in terms of being able to turn around product and be able to fulfill on the contract for the event with the downtown
Ms.
bid.
Valera,
And so I think we
Ms.
are
Valera,
all in the...
I appreciate all the background. Seriously, we do. But my question was, when was this particular application submitted and accepted by ABRA?
For the, and just so I'm clear, the one-day license and the substantial change were all both submitted last week.
What day?
They were in, it was submitted before the board met, so Monday or Tuesday of last week. And we submitted one day, and then they came back to us and said, we would prefer if you would submit a substantial change because then it ties to your existing license. And so we have more faith in the liability piece, given that nothing has ever been programmed like this at the park before with alcohol. And so we submitted then in addition, and this was all before the board met. So honestly, my understanding was this was going to the board last week.
So all of this was submitted before Wednesday of last week.
Yes.
Okay, thank you. Thank you.
But I just for the, if even if it was submitted, if the board meets on Wednesday, and if someone submits an application on Monday or Tuesday, that doesn't guarantee that the board is going to consider that on Wednesday. I just want the record to reflect that if information is provided to the board, to the agency, because we meet every Wednesday, so if information is provided to the agency on a Tuesday or a Monday, that does not guarantee that the board will listen or address that issue on that Wednesday. I know that as a general matter, just want to say as a general matter, our calendar is published the Friday before, at least the Friday before that. That's when our calendar, and so I'll just state that's when our calendar is published, at the Friday before the Wednesday. So when if there are events that are created after that date, that's how you end up having amendment to our calendar or amendment to our agenda. So you might see the first amendment to our legal agenda or licensing agenda because a special request is made that for the board to address this issue, because since the application itself was provided to the agency timely, and so we're not going to not address an issue or grant a license if it's provided to us timely. So if, for example, if it's provided to us timely, and if the event was last week, Wednesday or Thursday or Friday, we would have considered that your application. But maybe and I don't, without knowing specifically, because I have not seen the document, we will ask the agency to provide us with a document, and the board will revisit the substantial change or the temporary based on the representation, and we'll look at the documents that are provided to the agency and make a decision. All right. I think some of the questions, all right, so I think
Many thanks.
All right. I think some of the questions have been answered, so maybe you can tell us. So now let's move back to our permanent license. I did not believe that. I didn't think that the discussions would have taken this long for the request for April 2nd. So let's move back to the larger issue, why we're here. So can you tell us what has been envisioned? You have requested a permanent license for 20,000 occupants for the park. So can you tell us what is your business model? What has been envisioned here? Whoever can provide it.
Mr. Chairperson, before we move on to that, and I just forwarded it to your general counsel and assistant general counsel. An amendment was filed on March 2nd, reducing the requested occupancy from 20,000 to 7,500. So I'm not sure why that has not percolated to you, but we will be addressing what's intended with an occupancy of 7,500, not 20,000. And that amendment was made 3 weeks ago, and I've just forwarded the email to Ms. Jenkins and Mr. Berman, so that you could see that there's no question that that was done.
Okay, so we're now at 75. The total occupancy is for 7,500. It's 7,500. All right. And as I said before, we're having a fact finding hearing to gather information, and so that's why we have a fact finding hearing, Mr. Klein. And I appreciate the representation. We're gathering facts, and one of the pertinent facts that was provided today is that it's a 7,500 occupancy and not 20,000. All right.
Correct.
All right,
Correct. So with that background, I'll let Ms. Valero explain what the concept is and
go
what's.
ahead, Ms. Valero, please.
And I can speak also to sort of that amendment on the application. So Franklin Park is 5 acres in downtown DC. As I mentioned before, the DC government has built a beautiful jewel box space on that park. We are leasing that space in conjunction with the downtown DC bid. And so that will be the main retail space where the CT license would be. And then given that the goal of this is to really create sort of like a Bryant Park in DC. So how do we really activate that space in the park itself in order to ensure that guests can enjoy the park and can enjoy beverages in the park? And so part of the reason for the amendment is based off of the management agreement between the downtown DC bid and National Park Service. A certain percentage of the park must always remain open for the general public to be able to utilize. And so that's one of the reasons why we made that reduction, because part of what we are also helping to manage with the bid is that park being utilized for events outside of just people who want to come to the park and come to the cafe and have a beverage and sit outside. It's also so that if you think about things like 5K finish line races or someone wanting to get married in the park, that would also fall underneath this license application. And so this is really in order to ensure that there's one licensee who is helping to manage the liability around alcohol in the park and able to enjoy and able to ensure that there's a security plan in place for all of those events. And so that was part of the intention. As we had talked with ABBA originally, what they said was probably best from an application process is for that to get endorsed as a summer garden under a summer garden permit for the park off of the tavern license inside the cafe space.
Now, so what space will the license cover? If we're to grant a license, what space would it cover?
I think that's part of the conversation. So from our standpoint, it would be based off of that percentage that National Park requires. It would never extend beyond that percentage. So if you say, I'm going to throw out a number here because I don't know that number exactly off the top of my head. I believe it's 60% of the park. That 40% must always remain open to the general public. And so it would be based off of that percentage of the rectangular lot. And so if that's if that percentage or, everything is broken up into lawns in the park. And so the lawn and the fountain pavilion space and such, it would be based off of us ensuring the perimeter of the entire park from an alcohol safety standpoint. And then there being a limited area within the park where the activity was taking place.
And as I before, now I'm confused. So therefore,
So if I could try to clarify, Mr. Chair.
Yes, Mr. Klein.
Yeah, I mean, the point is that there be flexibility in terms of the spaces used. In terms of occupancy, it would be limited to 7,500. I think your question was how many, and that's the number, 7,500. In terms of what areas, the idea is to try to leave that flexible, depending upon programming and depending upon the events and what areas are used. That's the concept, and that's what's hoped to be done here, is that the entire park would be licensed, but there would be a limitation on occupancy of 7,500. I hope that helps.
Now, the park would still, it's an open area that folks would anyone could walk into the park, or is there fencing? I'm just trying to explain to us the layout of this area that we're licensing.
The idea is that it would be flexible. As I said, the entire park would be licensed. The Park Service has a requirement that a certain percentage of the park be open to the public at all times, but that is not a fixed area. So it's not as if they're saying 40% and it's this 40% that has to be open. They're saying, depending upon what your programming needs are and what you're doing, at all times you must leave 40% of the park open to the public. So Ms. Valera's challenge, and what the board would be concerned about, is okay, what areas is alcohol being served? That would vary from time to time, and it would be up to Ms. Valera and her company to police that and provide the appropriate perimeter to satisfy the Park Service, because the Park Service needs to know that 40% of it's going to be open. But she would retain responsibility for the entire park with respect to the service of alcohol, and anything that was going on there, she'd be responsible for policing.
So, but if 40% of the park has to be open for public, okay, what would prevent me from bringing my bottle of wine or my beer to drink in the 40%? It's open to the public, so I can, and it has to be open to the public. So what's going to prevent me from drinking my bottle of wine or my champagne or my beer or whatever it is? And what's going to prevent a young under 21 person to go to a public park?
Laws against the public consumption of alcohol and laws against the public consumption or the consumption of alcohol by those under 21. That's the law. I mean, I can't guarantee that people aren't going to break the law.
I'm sorry, Mr. Klein, but who is it that this area is the 40% area which is open to the public? Now, I'm sitting there drinking my beer when the ABRA investigator comes, and there's someone in this area, since the license for the entire park, there is someone in this area, in the 40% area, drinking their beer or under 21, who's responsible? I mean, the licensee is going to say, that's a public area. I didn't sell them alcohol, but there's someone drinking or there's an underage. So how is the investigator supposed to know that in this area, where did this person get the alcohol from?
I mean, Ms. Valero, under those circumstances, if her staff observed that, would be on the phone with MPD and saying there's someone publicly consuming alcohol in the park. I mean, that she doesn't want those difficulties. I mean, again, no licensee can guarantee that people are not gonna break the law, you know, outside their front door in a brick and mortar establishment. I mean, there's just no way to there's no way to guarantee that. People need to comply with the law, and if not, then they need to be reported to the proper authorities and action needs to be taken. But no licensee is in a position to guarantee that, whether they're in a public park or whether they're in a building on K Street.
That's one of the challenges that has to be addressed with granting this license for a public park, a park that 40% of the park has to remain accessible to the public. So I guess what I'm trying to find out, what type of events do you plan to have on this event? Is this just a tavern, or you have a dance floor, you have entertainment? I heard before, are you asking for entertainment endorsement? I've not seen the application. I heard before the ANC had made an inquiry about the concert series that were being held, and that neighbors were complaining about noise at 10 o'clock. So what hours are, and again, I have not seen the application itself. So what hours of entertainment, what is it that you're asking for this space?
Is that me, Andrew?
Go ahead, Anna. Yeah.
So I think what's really interesting about this project and about the park itself is that this is a partnership with the Downtown DC bid. And so based off of that, the activities that are taking place in the park must match the mission and the vision of that which the downtown DC bid dictates. We are there in order to produce them in conjunction with them and in support. But it's not like Anna decides that someone wants to throw a rave and suddenly someone's throwing a rave in the park. And so this is something that the downtown DC bid has essentially veto authority on any activity taking place in the park, and everything must get approved by them and through NPS. And so that's part of the cooperative management agreement, as you heard earlier, that is also part of that special event permitting process that has been created between the downtown DC bid and National Park Service. That also dictates, based off of that agreement, that unless it is an area in the park where the downtown DC bid has granted the right for alcohol to be served, National Park Service will apply, meaning that people cannot, no different than on any DC public property, no one can consume alcohol underage or bring it in. But as it relates to types of events, it's going to be very community-focused events. And so, you know, the goal of the park and the goal of renovation of the park district government was...
Ms. Valera, your internet is poor. And so I'm not sure if the court reporter, if she's picking up everything that you're saying, because your connection is poor. I don't know what's going on. I just want to let you know that your connection is poor.
I'm in a very old building downtown that we're bringing back to life. Is this any better? I can't get any closer to the window.
You're better, but I'm just saying you're going in and out. Just want to let you know that. All right.
I appreciate that. I'll try to speak slowly. The activities that are taking place in the park are activities that have to be aligned with what both district government has dictated to the downtown DC bid, are aligned with what the mission is of the downtown DC bid, and that's to create places where the community can gather. And so the activities taking place in the park will reach multiple demographics of people who both live and work in the district. And so you'll have a lot of family-focused community programming. There's a beautiful children's garden in the park. In addition, with some of the, no different than the rest of the bids in the city do, a lot of programming around how do we bring artisans into and create artisan spaces? How do we activate the park in ways that will also draw some of the young professionals in the city? And really the goal of the cafe space is to create a space where people don't just flock from downtown after work to other parts of the city. How do we really create spaces where people want to stay and engage? No different than people do with Jazz in the Garden on a Friday night in the summer. How do we create a similar type of environment where people want to stay and want to create spaces and want to create very Washingtonian type experiences in Franklin Park? That's our mission and that's the goal.
Well, one of the things that I noticed that you applied on your license, you applied for outdoor entertainment until 2-3 a.m. in the morning. So I know you talk a lot about a family friendly. I'm not quite sure. Maybe you need to explain what type of family friendly event that you're going to have outdoor entertainment until 2-3 a.m. in the morning.
You know, I think very respectfully, I think the 2-3 in the morning has been addressed with the ANC. We already met with the SMD ABRA committee, and this was part of the discussion with them. And part of the eventual settlement agreement that we have talked about with them has the times outside in the park itself ending earlier in the evening. We haven't agreed on exactly what that time is, but I think that's something that will get addressed with the ANC. And the inside is, again, you know, the hope for the cafe space is that it becomes a space where people can stay and can want to be there beyond, you know, people leave downtown at 7 o'clock right now once they walk out of their office. And so how can we start to create spaces that create a different type of atmosphere?
Now, so what occurs during I know we talk about, because it appears to me a major portion of the space is outdoors. So DC is not, we do not have outdoor weather for the entire year. So tell me about the operation during the winter months, I'm sorry.
You know, I think the winter months are going to be limited. I think that they're going to be limited to events that want to take place within tents. You know, no different than during the hot hot summer months of DC, people still want to have some type of shaded environment. And so, you know, that's something where we would go through the typical process in order to ensure that there were tents installed within jurisdictional guidelines for those events taking place in the park.
How are you gonna, what are your abilities currently? I know you said that, you know, if we allow this process to move forward, you have approached the ANC, and so that's another process but how do you envision currently controlling amplified noises leaving from the property?
I think a lot of noise mitigation can be based off of where stages are placed, and even if you need a stage, you know, I think a lot of the music and activities that will take place in the park will be either within more sort of tented areas, or kind of no different than we're talking about doing on the April 2nd event. And with those tent flaps down, it helps to contain the sound within them. Also, strategic placement of where those stages go. You know, I think part of what they found when they did the previous concert series was just changing the direction of the stage. It makes a huge difference in terms of sound mitigation.
Now, so tell us about how we're going to receive deliveries and how you're going to mitigate trash. Manage
trash. So the beauty of working with the Downtown DC bid is that they also have a full-time maintenance team, meaning that they are going around pulling trash from all of the trash receptacles within downtown DC. And so we can have daily pickups of trash. In addition, there's a trash compactor that's being trash and recycling compactors that are being placed at the building. And that will happen during the construction phase. And so we have multiple ways in order to remove trash from the facility.
Now, so tell us about your security plan detail, because now what type of security will you have in this facility, since it appears this is going to be you have a cafe, you're going to have from what I'm hearing, a large summer garden. So tell us about the security detail.
Gladly. So the building itself will be a very typical brick and mortar security plan. We'll have cameras with 30-day recording that are placed in the building and along the end, taking shots of all of the exterior. And then as it relates to the rest of the park itself, it's already currently patrolled. It's already currently patrolled 7 days a week, and we would add additional security based off of if there are special events taking place in the park, we'd add additional third-party security that would help to manage the liability and the compliance controls.
Now, I know you talked about cameras on the tavern itself, the cafe. I'm sorry, the cafe itself. Are there cameras in the park? Or are there any plans to have cameras in the park?
Yeah, I would defer to the bid.
I'm coming to you, Mr. Price. I have some specific questions for you, sir.
Oh, sure. Yeah, I was sure.
Go ahead, Mr.
Yeah, I was going to answer that question regarding.
But I'm asking her about, because they're going to manage the license is going to be granted would be granted for 60% of the park. And I'm hearing it's going to be a flexible, what's the 60%, what 40%. So I'm just trying to find out what type of security is it that the tavern itself, because we need to have, if an infraction occur, there's only one licensee. It's not the license will be granted to the spring, not to the bid. So we're looking to the licensee for responsibility, and they can't say that, you know, oh, the bid was supposed to have done that. We go to the licensee to say it's your responsibility because you're the one we have jurisdiction over. We're not going to have jurisdiction over the bid unless the bid is a part of the license. So
I think the easy answer to that is there are currently 8 cameras that cover the rest of the park facility itself, inclusive of the West Lawn that we have talked about. And then there would be additional cameras that are placed within the retail venue itself. So within the interior and on the outside the pavilion.
Based on the numbers that are being requested, would you have, if as part of the consideration of this license, would you have any concerns if the board or the agency board require having some type of security plan for this area?
We don't have any problem with that.
All right, fine.
No.
Let me, Mr. Price, let me ask you, who within the bid will manage the relationship with this applicant?
So it's we are really excited to be partnering with Anna and the team at Pirate Ventures, and so we have already been in close communication with me directly in my role as president and CEO. But then on site at Franklin Park, we have a full-time park manager who you have met, and Cicely Mindy, who is also on the call. And so her responsibility is to manage all things that are happening with respect to events and community engagements and coordinating, with our tenant who will be in that space. And so Cicely will be leading that effort. And then also providing further support, Ms. Steiger, who you've also met, who's on the line. She is also providing support in terms of offering the sort of structure and support that's needed at planning individual events happening in the space.
Now, this is a unique relationship. We have the National Park Service, we have the BID, we have the DC government. So what agents within the DC government is involved in this process moving forward, and how? Yeah, just explain to us the relationship, please.
Yeah, and I think Anna mentioned in her words in the very beginning, perhaps when talking about the temporary license, but the overall sort of structure of the park is a bit complicated. And this was a project that was a long time in the making. I think it took about 20 years total, including an act of Congress to authorize the ability for this management to happen. And so it was quite a complicated process, but the land remains owned by the National Park Service, so it is a federal park land, but the sort of management agreement that was referenced, the cooperative management agreement, which I believe has been submitted to the board for review, it basically provides for the city to have the jurisdiction over the space. And so the DC Department of Parks and Recreation is that guiding entity on the city side. But then they have identified the Downtown DC BID as the operator of that space. And so all of the day-to-day happenings in the park, with respect to anything you can imagine, from planning community events and engagements to maintenance and operations to capital improvements and projects, will fall on the BID through that cooperative management agreement. So it is our job to manage the space and to negotiate the lease with the tenant, and we're excited to welcome the Springs on site.
Mr. Price, I believe we have an agreement. I'm not sure if we might have the cooperative agreement between. I'm not sure if we have the. Do we have a copy of your agreement, the BID's agreement with the DC government? Do we have that? And if we don't have that, could you provide that separate agreement to the agency?
Can I ask you, Mr. Klein, is that it may have been submitted, or
Yeah, I think it's been submitted.
Okay,
We'll submit it again.
I'm sorry. I know that there is an agreement between the district and the district and National Park Service. Is that correct? And then there's an agreement between the BID and DC. I'm sorry, the BID and the DC government. Is that correct?
Yes, sir. That cooperative management agreement actually includes all three entities and sort of describes the relationship.
Okay. All right. So we have that. All right. So we have that. Let me see.
Mr. Chairman?
Yes, Mr. I'm coming to you, Mr. Grandis. Hold on 1 minute. I'm trying to see if I have.
Much.
Yeah, I'm gonna have the board ask questions. I just want to make sure. Go ahead, Mr. Grandis. I'll probably have some more other questions. Go ahead, Mr. Grandis.
I would like to ask a question to the ANC, and if one of y'all can decide who I should direct my question to, I will be glad to do that. Thank you. Okay. Having you all sit through this hearing and having you all been involved with apparently with the bid and perhaps this applicant regarding this event, I believe this coming Saturday. Is that correct? It's this coming Saturday. Does the bid have any, based on what we've been hearing today and based on the concerns you may have had regarding this event? I just have not any clarification on if you have any recommendations regarding this particular situation.
And this is Brian Romanowski, the ANC. Can you just clarify a little bit more? Sorry.
Yeah. Yes. Do y'all want the event this Saturday? Do y'all support the event this Saturday? And if so, with what limitations?
We do with the noise limitations, I think that Commissioner Joseph described earlier, that I believe the applicant has said that they will stop music at 8 p.m. Is that what it was earlier? Music outside the tent, I should say.
But inside the tent, it's 10 p.m.
Yeah.
So the ANC representation today that they support this event to go ahead with if the noise concerns are addressed.
Yes, and I believe the tent is positioned on the west side of the park, and so that is good news because the complaints that we've previously received are from residents a block away from the east side of the park. So I think that's also helpful.
Okay, and just for clarification of this record, I don't believe technically that this parcel is considered a federal park. I think it's considered a federal reservation. And I only bring it to the attention of this hearing because there's differences of regulation regarding what are considered legal federal parkland from what are federal reservations. And I just bring that just for the edification of this hearing. Thank you. Thank you, Mr. Chairman.
All right, thank you, Mr. Grandis. Do we have any other questions by the board members? Go ahead, Mr. Short.
Thank you very much. So I'd like to get this straight, Mr. Chair, from someone. So now the park, before any licenses are permitted to anybody to own a business, it's a public park. And so how does this remain public if 40% of it can be used and we're not saying where on the park, 40%, 60%, since they're going to say, well, this week we want to use the west side, next week we want to use the east side. So it's not a public park anymore. It's a public business park, I guess we'd call it. Or I'm just trying to figure out the public, which has always used it before. It was taken over by homeless people and whatever else. It was any part of the park was public space. Federal government owns it, so it means federal dollars or whatever else had maintained it. But I just want to go to the fact that as a resident of the District of Columbia or someone who lives in the area or works in the area, and I decide I want to go out and I want to just lay in the park or bring my kids down to the park, then the tent might be anywhere on the park because we're not giving me any parameters other than to say wherever they decide to move it from week to week. So I'm just saying a business. And then also I have questions about will they pay the same amount of taxes that the brick and mortar businesses right across the street from them are paying? And how will those taxes be collected if we're going to tax them at all? Dealing with the trash and trash pickup. We know through a lot of other events that happen in the city, i.e. pub crawls and etc. They make agreements when they first get started, but then they say, well, at 2 o'clock in the morning when we close, we can't clean the park. So we have to wait until the next day. And so the next day, depending on the amount of trash and the number of people, and we're saying 7,500 every time they open up, and we're saying 7,500 until 2 o'clock in the morning if this board were to give them a permanent license. I just have a lot of questions that I haven't heard addressed or answered. And again, I just have to deal with the fact that once was a public federal park in the center of Washington, D.C., is now going to become a quasi-public business park. If what I've heard today is true, I'd like I'd like for the board to consider, and for the ANC and for the neighborhood to consider, and the bid to consider, are there any plans drawn up that we'll see where the parameters of the selling of alcohol will be, or as what we've heard testimony today is, it could be here tomorrow, and depending on what they want to do next week, it could be another part. So what part is public as a resident? Can I depend on going to the park any day of the week, knowing, okay, there is a business on the other side of the park, but this week it's on this side of the park? And so I think that a lot of things have to be explained. I think some plans and drawings should be submitted. And if they're going to have 7,500, I don't think that 6 toilets are going to satisfy 7,500 people. I just don't think, in my mind as a public person who's been around public safety and those kinds of events all my life, I'll just simply say this. We need to make some very serious considerations. And I'd like for the ANCs and the bid to, when these same questions are asked by the people who elect them to office, or by especially the bid who are given these privileges, are we giving our park away, or are we giving part of it away? Or are we saying it's not a public park per se anymore? It's just a place where business takes place, any place in the park. And we're going to say to the bid, you regulate this. So if someone is overserved alcohol, or if someone doesn't follow by the rules, oh, just call MPD. Well, suppose MPD is busy with a call in the community for the citizens who pay their salary. So again, there's a lot of questions I have, and I hope that we get some answers to them before this board votes on it. And I thought today we were going to be talking about the 1 day, but now we're talking about the total license for 7,500. And I'm just glad that maybe the chair has, in his wisdom, decided, let's get it all out on the table at once. It might be a good idea. So again, I just have those questions to ask, especially about trash compactors, other things on the trash pickup on a regular basis, music at 2 o'clock in the AM in downtown Washington, D.C. I just have a lot of questions that I haven't heard any answers to. And if we could get those answers out, maybe as a board member, I could wrap my mind around giving 60% or 40% or however it's going to be divided up to private interests. Thank you very much for all who heard my comments. Thank you.
Hold on a minute before I get a response. We had a fact-finding hearing. This fact-finding hearing was scheduled for a while on our schedule, and the purpose of this fact-finding hearing was to address the application from the Spriggs to apply for a license. Initially, it was for a license for 20,000. On March 2nd, the agency, the application was amended for 7,500. And so the purpose of this, this was a fact-finding hearing to see whether or not the board believes that this application can move forward to the process. And which is the regular process. And the regular process is that if we determine that this is a viable application, then it will be placarded, and then the ANC at that juncture would have the possibility to protest it. So we haven't gotten to that stage where this is still the information gathering stage for us to make a decision. Is this ripe to move along through the process? So the board is not making any decision on whether or not we're going to grant a license. It's just, do we have enough information to send this out? And this is unique because normally the public is not a part of this type of process. The public is usually not aware of the application until the board has made a determination that it needs to be placarded, and then we'll take public input. But this is because of, as everyone has stated, this is a first impression for this board, and I think it's a first impression for this city, in the sense that we have public National Park Service that I was told it took over 20 years for the Park Service to even turn some type of management of the land over to the district. The district, I'm told, paid almost $3 million of taxpayer funds to renovate this park. And so therefore there are agreements between the Park Service and the district, and there's an agreement between the district and the bid, and then there's an agreement between the bid and a potential applicant. And so we're just trying to get through to make a determination that moving forward, where do we move forward? And I appreciate the fact that Mr. Valera, that what you're posed on the record today is that this is a process that you have been talking to the agency, and the agency has been trying to say to you what type of, looking at the different license class, to say, based on this first impression, what it is that you think that even for the event on the 30th, on the 2nd, what's the appropriate type of license that you should apply for based on the novelty of it. So I like the fact that that information was put on the record, because I think this is kind of helpful for the public, because sometimes this agency has been told that we're not working with the licensees, and here it is that we're being told that this has been a long process, in a sense of trying to figure out what's the appropriate type of license based on the uniqueness of the situation. I have some other questions I'm going to ask. I just want to let the parties know that I want to ask some specific questions about the permit, the permit number 22-0197 that covers this quarter, the quarter April 1st to June 22nd, 2022. So if you have that permit, I would like you to, I have some specific questions that I want to ask you about that permit. So either the bid or Ms. Valera, if you have that, please pull that up so I can be provided a response based on some questions that the agency have regarding some languages specifically in that permit. So, Mr. Short, were you asking a question, or was it just a general comment?
Mr. Chair, it was a question that I was asking. Right. And I was trying to get around to the end of my question when you and your wisdom as our attorney and our board chairman. I do understand, Mr. Chair, that my question was not completed, and so if I might be permitted, okay. Well, thank you very much, sir. Again, my question totally is the fact that a 100% city park that's been granted permission by the federal government to be used by the city, in which the city has put $3 million in renovating, is now not going to be a total city park anymore. And if it's not going to be a total city park, those persons who are permitted to sell alcohol, serve alcohol, and maybe even store alcohol on a public space, if they're going to fall under the same parameters as a person who has a brick and mortar, which is right across the street from them on 14th Street or 13th Street or I Street or K Street, do they fall under the same parameters with Arbor rules with the sale, service, and storage of alcohol? Or is it going to be, well, since this is a hybrid, first time that I know that an ABC board has been asked to grant a license in a former federal, well, not former, but in a federal piece of property that's now been granted permission to the district government, that this park is now, from what I've heard today, how much is it going to be business and how much is it going to be park? We're saying 60-40 or 40-60. I've heard different numbers thrown out. But again, a park that was quiet at 2 a.m. is now going to be permitted, if the permit or licenses go through. They want to be open to 2 o'clock in the morning in downtown Washington, D.C., outside under a tent. But at any rate, that's not my question. My question is, if this is not going to be a park anymore and it's not a hybrid piece of property for the district government or the citizens and visitors and businesses to use as a federal park, then how much or how far is ARBA, the ABC board, the ANC commissioners, or the bid? Where does it go? Where does it end? Are there going to be diagrams presented to the public so that they can know exactly where the public goes and where the business goes? Are there going to be instances where if it's going to be 7,500 people, the mayor's special events committee is going to get involved? Because normally when a crowd that size is downtown, the mayor's, i.e. cherry blossom parades or whatever else, the mayor's committee on public safety or the mayor's special events committee, they get involved, and that involves all the other agencies. So if we need extra policemen down there during the time there's 7,500 people, the police department can set aside those resources. Other government agencies who might get involved, DPW, traffic patrol, all of those people need to be involved, because it might not sound like a big number to us right now because it's all on paper, but I would venture to say we need to be prepared if that is what this board is going to decide to do with a park in the middle of Washington, D.C. downtown. And my question is, Mr. Chair, what part of the park is going to be still for the public to use, and what part is that? And what part is going to be now business, and what part is that? And is that going to be in stone, or is it going to be 1 week we're here on the west side, 1 week we're on the east side, 1 week we're on the south side, or one week we're on the north side? So I think that we need to have some parameters, exactly how the taxes are going to be collected, exactly how they're going to be required as other government regulators, alcohol businesses in the District of Columbia. Do they apply by those rules, or are we going to make them up as we go by the seat of our pants? That is my question, Mr. Chair. And if you want to answer that, fine. If the bid wants to answer it, or the ANCs, whomever, or the applicant, but someone, I just like to have those questions answered just for myself, I guess. But at any rate, hopefully it'll be helpful to the whole board. Thank you, Mr. Chair.
I'm going to try to answer it.
Hold on. All right. I guess Mr. Klein wants to answer, and then I'll have the bid, because this is a larger issue, and so
Yeah.
the bid can also. Mr. Klein, you represent the Sprigs, so but I think this question. It's a larger issue that we probably need to get a response from the bid, because since the bid, your client is a subcontractor from the bid. So
The client's the applicant before this board.
Yes, sir. But there's I know that, Mr. Klein, and I'm going to get to you. And I always give you the.
I feel like a potted plant today, Mr.
Mr. Klein, you will never be a potted plant. And one of the things that you should be, that I've always done, Mr. Klein, I always give you the last word. And therefore, you will always have an opportunity to if someone says something that you don't like, or they didn't say incorrectly, you can always correct it. You can always clean up. I would think that you would want to be the last person, because the bid might say something that you don't agree with. So then you have an opportunity to clean that up, sir. So
I appreciate that. I just thought I could save us some time by trying to address some of those issues.
well, clearly this is a very unique situation, and you're correct. Mr. Short did ask a pertinent question, and I am also confused in the sense that 60-40, and so there are some issues there. So we'll have Mr. Price respond, and then you will get an opportunity to respond on behalf of your client.
Thank you, Mr. Chairman.
Sure. So I'm happy to, and I will just say off the top here, I'm not going to be able to answer every part of Mr. Short's question. Mr. Short, you asked quite a few things, and I think all really valid points. And I just want to say how much I appreciate your thoughtfulness and your concern here. Clearly, as a longtime DC resident, you understand the context and the history of this park, and sort of understand the role that it plays for a lot of Washingtonians, and myself included. I mean, I think, for us as operators of this space at the bid, we're being entrusted to operate this space so that it remains a public park. And Franklin Park will be a Franklin will be a park that is open to all people to enjoy and to come and access and enjoy as best as possible. One of the things that I just wanted to flag, and I don't know where the number 3 million was coming from around the renovation work, but it actually was a much more significant renovation investment made by the city. In total, $21 million have gone into renovating that park space. So it is quite a big investment from the city. And as we mentioned before, a number of years of planning and conversation, both with the Park Service and the city government, to get us to the point where we are today, where we're able to have a beautiful space in the heart of downtown, where we can welcome folks for public events and community events, and just the quiet enjoyment of what is a really beautifully done space. And so I wanted to sort of just quickly acknowledge that, and then to say that, with respect to the breakdown and the private versus public and sort of that, the question that Mr. Scott posed, I just wanted to touch on and say that there was intentionality from the very beginning in some of the earliest conversations with the Park Service and the city, and that the bid was involved and sort of helped to bring forward around allowing for there to be a retail establishment in this park, modeled off of the best practices of a number of other cities that have gone this route in terms of having retail establishments in their spaces. Looking at places like Bryant Park in New York City, it is not only helpful in terms of bringing vibrancy and just drawing people to the space, but it becomes a revenue generator to sustain the maintenance, operations, and capital improvements of the park. And so this business component is a critical function to ensuring that Franklin Park remains in good condition and remains a asset for years to come. And so I just wanted to acknowledge that was something that was planned in the front end, and it's been a long-standing part of the plan for the future, long-term future of the park. And so we are super excited to be welcoming the Springs into that space to operate the business in the actual building itself, which is in the south side of the park. And our intent was always that space, it's a private business that is accessible to anyone who would like to enter it. And so that is part of why what the Springs is proposing. It's a cafe where folks can come to get certain types of items throughout the day. But what we also thought was really important was to think about how that space can also help to activate the rest of the park. And so, when you talk about the split and should there be sort of designated drawings and spaces that are accessible, we've bounced around that idea too. And it's something that there have been a number of meetings and conversations around that very concept. One of the challenges is that, we think that there are going to be really dynamic and changing needs and different kinds of events and activations that will really warrant different spacing, different positioning, and really thoughtful planning. And so it'd be really hard to have sort of a catch-all that would work for all the types of things that we think are possible. I'm not sure who mentioned before that, the Jazz in the Garden sort of concept, if you've ever gone to when the Smithsonian does that event. That was one of the things that the Park Service kept sort of referencing in their early visioning of what this space could mean and could be. But thinking about, a quiet, sort of evening of jazz in the park with perhaps folks enjoying a glass of wine, right? And that maybe that happening on the East Lawn in the summer months, but then perhaps having a different kind of event that would take place on the West Lawn that could accommodate a slightly larger crowd. And sort of thinking about sort of just different ways to set up and host these types of events. It would be really challenging to sort of to box it in and say only in this particular square could something be served. And so the thought was always to be fluid and sort of have that space for flexibility. Other thing that I just want to say in answer to Mr. Short's question, around sort of how to maintain that appropriate balance of private versus public and what's accessible. Our goal as operators in that space, and actually our responsibility and requirement, is to engage with the Park Service, as Ms. Steiger mentioned, on a quarterly basis to provide our plans for what types of private events are happening in that space. We have the general provision to have private revenue generating events in that space, but it must be balanced. And so the Park Service is not going to approve, if we said 100% of the time the West Lawn will be taken up for a tent and an alcohol serving event, the Park Service would not approve that. We have to get that okay through that process that we have each quarter to be able to say these are the planned private events that will be taking place. And even with that, there's a difference between a private event that is closed to the general public and then an event that is taking place in the park that is serving alcohol, that is open to the public to purchase items as they wish, right? So there's even a balance to strike there. And so just wanted to sort of offer up that distinction as well. So very complex and complicated set of questions. And I don't know that we're going to figure all of this out on this hearing today, but just want you to know that a lot of consideration has gone into sort of how to structure that, and really the responsibility for the balance falls on the bid, and is certainly a part of our frequent conversations with the National Park Service.
Thank you.
Mr. Klein, do you wish to provide a response?
Just a few things. I mean, Mr. Short has raised some concerns, and they're certainly legitimate with respect to any operation. This is unique, and I think as we've tried to lay out, there's been an effort to cooperate all along. There are a number of different groups that are involved here, and nobody's in the dark. And there's really an effort to make sure that there is a good use of this space and good compromises concerning the various interests. I want to turn back to something that I said at the outset, and I know, Mr. Short, you have concerns about this public property being used. I know this park. As I said, my law practice started around the corner many years ago. And it's beautiful. With the renovation that's been done, a lot of money has been spent. But I've seen this park renovated before. And it was renovated, but without it being activated, it will be a scary place again. And that's, the purpose of this is to enliven it, is to make it like Bryant Park in New York or other parks around the country in urban areas where people will want to come and people won't be afraid to walk across it. Because I've been down there and been afraid to walk across it. And that's, that's the purpose here. Now, in terms of your specific concerns, there is a very serious question, given that this is federal land, that this even needs a local ABRA license and a local ABC license. But no one's here to raise that question. I mean, one of the reasons that we're here is we welcome, and the bid welcomes, and the Park Service welcomes your oversight. And in terms of how taxes are going to be collected and what rules are going to apply, yes, Mr. Short, the same rules that apply to a brick and mortar business will apply to this ABC licensee, because they're going to be an ABC licensee, which means they have to collect and remit the 10% sales tax. They have to pay their employment tax and all the other taxes that are involved in running in a brick and mortar space. They won't pay real estate taxes because that's not part of their business deal, but there is a percentage that's being paid to the bid to help maintain this park, as Mr. Price mentioned. So all of the regulatory features that you see with respect to any other business will be in place. That's why we're here. Even though there's some question as to whether it's necessary, not a question we want to raise, because all of us agree. The bid agrees, the Park Service agrees, Ms. Valero agrees that the best way to move forward is through this process and having your board and your agency having oversight over this business so that the public is protected. And all parties have worked and will continue to work with the ANC and the other affected residents with respect to the operation here. So, I understand concerns, and this is a discussion we have, for example, with public space applications all the time, the argument about appropriation of public space for private use. But that's not this discussion. That's a discussion among the Park Service, the bid, and Ms. Valero, and what have you. We're here to ask about having this facility licensed by you so that there will be the appropriate oversight. So the concerns that you raised, Mr. Short, will be addressed in the normal course of business in accordance with district law. So we would ask you to allow this to move forward. We've already started working with the ANC and will continue to do so to address some of the other issues that you've raised in terms of concerns of residents. And I'm pretty sure, given the progress that's already been made, that those will all be worked out. If there are any specific questions, there was a lot to unpack there, but I think we've generally tried to address the concerns that have been raised, and of course, we're happy to answer any other questions that any board member has.
Mr. Price, I think it's more of a issue for you, a question for you. This is regarding the permit. I'm not sure, do you have a copy of the permit in front of you? The permit 22, the permit that covers the period April 1st through June 30th, 2022. And their provision C and D. C says that the permittee is responsible for obtaining the necessary permissions and or additional permits from the Metropolitan Department or from other federal, state, or local agencies or departments for the use of public lands other than those under the jurisdiction of the National Park Service. And letter D says, pursuant to the philanthropic partnership agreement between the National Park Service, National Mall and Memorial Parks, and the Downtown DC Business Improvement District, and the Downtown DC Foundation is authorized to the sale or service of alcoholic beverages as part of a permitted activity and fundraising event approved in the annual work plan. And then it says the annual work plan did not include any activities wanting to serve alcoholic beverages. Well, are those two provisions in conflict, and why is it that we're then being asked to grant an alcohol license to this licensee if it appears that this agreement doesn't contemplate that alcohol would be utilized? Am I missing something?
I am trying to pull up the actual permit. I did not have it in front of me, so I'm working to get that. Right now, I was not aware of that particular line that you're reading.
Remember, I told you guys 20 minutes ago that if you have the permit, please pull the permit, because I'm going to ask a question about the specific permit. I mean, do you, Mr. Klein, have a copy of the permit? Can anyone address?
Mr. Klein, you might be on mute.
I have it up and I can share it if that would be helpful.
Can anyone address that? I'm just, it's a concern. So since all the parties are here, maybe someone can address that aren't these two provisions in conflict? And if they're not, let us know. I said before, we don't want to go through the exercise of saying that this process can go forward, and then the National Park Service says, oh, by the way, you can't do that. I don't know. I'm sorry, who's speaking?
Cicely Mendy, I'm sorry. So I do see what you are saying. I am looking at letter D, and I'm a little, to be quite frank, I'm a little confused by it, because we had the conversation with the National Park Service, and one of the things that was stated by the National Park Service was that we did not need to go through ABRA for even this process that we're going through right now, and that the retail operator would indeed be able to serve alcohol. We did place into the annual work plan the fact that this event would specifically have alcohol being sold. So I am a little bit taken back by what you're reading right now. But certainly, the National Park Service is aware of the fact that alcohol is going to be served at this event.
Yeah, I actually think that this might have been a standard line that was in here and inadvertently included, and certainly can take this back with the team at the Park Service. So we've had explicit conversations about events that would include alcohol being served during this time period. So I'm not sure why that line is in here. No, it's frankly the first time I'm seeing this, to be honest.
Okay. Well, this is this whatever decision the agency, the board makes today, it's not going to happen overnight, because if the board determines that this can move forward, what the board's going to say is that it can move forward to be placarded to the 45-day placarded period. So, you still have an opportunity to correct this. So if a major error is made, then that can be corrected through the process because you do whatever, because you'll have some time to provide an updated agreement with to the agency. And whether or not
Excellent.
I think the bottom line is that it's always my position as board chair is that if there is an entity within DC that sells or serve alcohol, we should have jurisdiction over it. That's just my personal opinion, because as far as the ANC is concerned, if there's a noise complaint or something occurs, they're going to call Abra. And I don't want us to be in a position by saying, although we are the agency in DC, but we don't have jurisdiction, so sorry, we can't help you. So my personal opinion is that I want us to I want us to regulate every entity in DC that sells or serve alcohol, because the public, they're going to turn to Abra to say, you, Abra, needs to do something about it. And I don't want ever that Abra is in a position to say, I'm sorry, general public, this is not ours. We don't have jurisdiction, so we can't help you. And I don't think that's something that the ANC would ever want us to state. And I see Ms. Joseph is shaking her head, and so I'm just saying, as a personal, I do appreciate that applicants come to us for a license to say that, at least so we can be responsive to the residents of the District of Columbia over every licensee in DC that sells or serves alcohol. But again, because of our status, that's not always true. But to the extent possible, I want to make sure that that occurs.
Absolutely. And thank you for clarifying that. I think I'm sorry, Cicely. Yeah, I was going to say I'm relieved to hear that we have a little bit of time to do that. I think we should certainly engage NPS and get that corrected. It looks like a holdover from the last permit where we didn't have any events. They just need to change that line. I think likely it was just missed, but I certainly appreciate that.
Any other questions by the board members? And then I will, Ms. Joseph, do you want to, any questions by the board members before? I know that this hearing has been, our hearing, our day is out of whack, but that's not a problem. Because I think this is an important issue for us to take as much time as possible to address. And so I'm not hurrying anyone. The board is going to take a lunch break, and at some point our afternoon schedule will start. But I'm fortunate that we were supposed to have a protest hearing this afternoon, so it's no longer in play. So we do have some more flexibility with time, so that is good. Although we still have 2 show cause hearing this afternoon. But anyway, any other questions by any other board members? I'm going to do a wrap up. So I'll start with the ANC. Any comments by the ANC prior to us? You're going to have you always have the last word, Mr. Klein. So any comments by the ANC?
Thank you, Chair Anderson. Yeah, I'll just say, I've lived 4 blocks north of Franklin Park now for 8 years, and I think this is probably the most amount of excitement that I've seen the community express in the development that's happening there. So just to address some of the points that Mr. Short made, I know even myself, I've used that park more in the last year than I have in the 8 years that I've lived here. So definitely looking forward to, the developments that are happening. As a representative 2F, we're also excited that this is a destination for other folks from DC to come into. So we're looking at this also as an economic development opportunity for the businesses, especially many of those in that K Street corridor that have been affected by the pandemic and are still struggling with folks not coming back into offices. So we're looking forward to that, bump up in the economic development of 2F as well. And then also for options for our public to be able to enjoy outdoors. We're still in the middle of the pandemic. I know a lot of people are still concerned. And so the people that I've seen in the park are often people with small children who don't have access to vaccines yet. So generally, this does seem to be a solid investment. Now, that being said, I think Chair Anderson, you definitely raised some great questions about, oversight. So eager to continue to work with you all. But generally, we are supportive of the park and its ongoings and look forward to working with the team to alleviate any concerns that have come up thus far.
Thank you, Ms. Joseph. Comments, concerns about the bid?
Cicely Mendy, the only thing that I would like to add is, as Ms. Joseph stated, the park has been open since September of last year. And in the time that we've opened, we, I believe, have done just a great job of making it a space for everyone. It is accessible. It's friendly, it's clean, it's safe. We have overnight security, we have the cameras, we have everything that we need, but we've also had programs and they've been very successful. We have had few complaints, and in the complaints that we've had, we've taken those opportunities to learn, and to make the changes that we need to make to continue to operate this park and make it a great public space for all. And yeah, it is also a destination space. It is not going to be a space that's going to be privatized exclusively. It is going to continue to be a public park. And, we're just excited for opportunity to be able to continue to do the work that we're doing there. Yes, thank you.
Thank you, Ms. Mendy. Mr.
Very
Price?
well put, Ms. Mindy. I appreciate you saying that. And this is Jaron Price. Just last thing I would say is really just echoing that. Glad to hear the excitement from our ANC Commissioner Joseph just around sort of what it means for the community. That has been our experience and the feedback that we've received as well. And I just want to thank you, Chairman Anderson, and thank you to the rest of the board just for your time and thoughtfulness around this. We recognize this is a complicated jurisdictional challenge. It is a sort of new challenge for us to tackle. So we appreciate the time and the energy that's gone into this thus far, and look forward to any continued collaboration that may be helpful as we're sort of moving towards the process. We'll flag that we are very hopeful that the event for Saturday will be cleared, and that we are really looking forward to it. It is a part of the official calendar of the National Cherry Blossom Festival, which is a huge deal for the bid and just for the city as a whole. And looking forward to Saturday being a success. I just wanted to flag that we are hoping that will happen. But thank you again, and appreciate your time.
Thank you, Mr. Price, Ms. Valero, and Mr. Klein.
Just a few words. I echo the comments that you've heard. I appreciate Chair Joseph's comments and also the comments from the bid. Appreciate you holding this hearing. This board is to be commended for always welcoming and looking at novel approaches to doing business, but balancing that against the need for oversight. And I think that this hearing is an apt demonstration of that. And although, hard questions were asked, they always are, but I think we've answered them. And if other questions arise, we're certainly available and we'll try to answer them. We think that this is something that is terrific for this neighborhood. And you've heard the ANC's comments who echoed that, and you hear the bid. He's obviously very supportive, and appreciate your consideration of it, and hope that you will support it going forward, exercising the right balance in allowing new types of activities and new types of concepts against the necessity to regulate, which is both of which are part of your jobs. And it doesn't go unnoticed that you do a good job of that. And I know the citizens of the District of Columbia appreciate it. And the questions here today were welcomed, and hopefully were answered to your satisfaction. Thank you.
All right, thank you. Thank you, Mr. Klein. Thank you, Ms. Valera. Thank you, Mr. Price, Ms. Mendy, Ms. Joseph, Ms. Steiger, Ms. Romanensky, and I'm bad with names, I apologize. But I want to thank everyone for participating in this hearing today. This has been very helpful. I mean, as I stated before, it's a fact-finding hearing. We're gathering information, and the purpose, what the board charge is today, is to make a decision whether or not this is an appropriate license to move forward. Move forward meaning that should this be placarded, and so therefore meaning that we now inform the public that the Sprigs have applied for a license, and that the public will have 45 days to either protest are not protests. And so therefore it would be an opportunity for the licensee, and I know that Mr. Klein's aware, to engage the ANC, any civic association that's in the area who might have or abutting property. I don't believe, because it's a park in the middle of the city, there are no well, at least it's not apparent to me that there's any abutting property owners to say who would have jurisdiction to protest this. But this would be then an opportunity for the public to weigh in, to see whether or not they believe that this is an appropriate action for the board to take. So as I stated, that this is the process moving forward. So we'll make a decision whether or not we will allow this process to move forward. Not whether or not we're going to grant the license, it's to allow the process to move forward. And as I stated before, the process is whether or not we should now inform the public that an application was filed. We will also make a decision. I am not clear exactly when the substantial change request was made. I'm not clear, but I will ask the agency again to provide us more information exactly when the substantial change request was filed. If the substantial change request was timely filed to the agency, we will consider that. That's why I said not, if it was timely filed, we will consider it. If not, if it's not timely filed, we'll not consider it, and we will make it an independent determination on the temporary license. But the decision will be made at some point this afternoon when the board comes back on for the public hearing. We will vote publicly on all the agenda items. So it's not on our calendar, so we probably would have to amend our calendar to add the substantial change, amend the licensing agenda to add the substantial change if it was timely filed. If it was not timely filed, we're not going to amend our calendar, because we need to let the public know that we're voting on something that's not on our published calendar. But we will do that before the end. So you'll get a decision before the board adjourns for the day on those issues. All right, so thank everyone for your attention today. I know the afternoon session for the board was supposed to start at 1:30. It is now 2:10. The board is going to go to lunch. So we will come back for our afternoon session at 2:45. So 2:45, we will have our afternoon session. I'm going to ask the board members to quickly go to executive session for about 5 minutes just to do some housekeeping before we go to lunch. But again, thank everyone for their active participation today. And we're adjourned for the day. We will be back on the public record at 2:45. Thank you. Have a great day.
Thank you,
Thank
Chairman.
you.
All right, bye-bye.
Thank you. Take care.
All right, bye-bye. Good afternoon. We're back on the record. Good afternoon, everyone. Welcome to our afternoon session of the ABC board. I do apologize to the general public. Our afternoon schedule was supposed to start at 1:30. I know it is 3:10. However, our morning session ran much longer than we had anticipated. And so I do apologize for the delay for our reconvening this afternoon. Again, welcome to the afternoon session of the ABC board. My name is Donovan Anderson. I'm chairman of the board. Joining us this afternoon are 5 other board members. We have Mr. James Short, Mr. Bobby Cato, Ms. Rafi Crockett, Ms. Jenny Henson, Mr. Edward Grandis. The board has 6 members in attendance this afternoon to conduct business, and we do have a quorum to conduct business. Before we get underway this afternoon's calendar, I need to make a few instructions very clear so that the conduct of these hearings is understood by everyone. We have, I believe, 4 cases on our calendar this afternoon. Once your case is called, I will take a moment for IT specialists to elevate the rights of each party to enable their camera and microphone. Then and only then will you have the ability to enable your equipment. If your case has not been heard, you will remain mute and your camera will be disabled. At the conclusion of each case, the parties will have the option to leave. If the party chooses to stay, all cameras and microphones for the concluded case will be disabled. Should you have any questions or require technical assistance during the hearing, please submit them using the question and answer feature. Our first case this afternoon is a show cause hearing, case number 21 CMP 00062 Empire Lounge, license number 110702. Ms. Washburn, can you please elevate the rights of the parties in this case, please?
Stand by. James Jordan, your rights have been elevated. Richard Bianco, your rights have been elevated. Felicia Dantzler, your rights have been elevated. That is all, Mr. Chair.
Thank you. Mr. Bianco, do we have all the parties on your side? Are they elevated?
Yeah, it's just going to be me today, Mr. Chairman.
All right, thank you. All right, good afternoon, everyone. Welcome to our afternoon schedule. And let me apologize to the party. I know this hearing was scheduled for 1:30. It is clearly not 1:30, but our morning calendar ran much longer than we had anticipated, so I do apologize for the delay. All right, so let's have the parties introduce themselves for the record. Let's start with the government, please.
Good afternoon, Mr. Chairperson. James Jordan on behalf of the district. It's James Jordan.
And Mr. Jordan, if this matter goes to a hearing, do you have a witness today?
Yes, Mr. Chairperson. In fact, 2 witnesses. This Investigator Dantzler and Investigator Brashears, I believe, should be waiting.
I don't see Investigator Brashears, so if I'll ask if Investigator Brashears is that his rights be elevated, please. Ms. Dantzler, can you please spell and state your name for the record, please? You're on mute, Ms. Dantzler.
Good afternoon. My name is Felicia Dantzler, Amber Investigator. My name phonetically is F like Frank, ELICIA, D like dance, D like David, ANT like time, Z like zebra, LER.
Good afternoon, Ms. Weasley. Ms. Dantzler, Mr. Brashears, can you please spell and state your name for the record, please?
Yes, sir. My name is Mark Brashears. That's M-A-R-K. Last name is B-R-A-S-H-E-A-R-S.
Good afternoon, Mr. Brashears. Mr. Bianco, can you please spell and state your name for the record, please?
Sure, Richard Bianco, RICHARD BIANCO.
Good afternoon, Mr. Bianco. As I stated before, I don't see you having witnesses, so let me find out from the government. Mr. Jordan, are there any preliminary matters in this case?
No, Mr. Chairperson, no preliminary matters.
And I guess I know that the government has the burden to prove. So as Mr. Bianca, as an attorney, we're aware that an attorney can testify at a hearing. So how do you plan to, excuse me, how do you plan to defend your client, sir?
Our defense in this case is consisting of essentially legal argument with respect to interpretation of the zoning code. As the board is aware, there's a component of 25-725 that requires certain zoning, and that's where our argument will focus.
Okay, Mr. Bianca, you don't need to go through that. I was just trying to get some clarification, so you could do that later on. I just wanted to get some clarification, how this matter is going to proceed. As stated before, we are aware that the burden is on the government to prove, and the licensee doesn't have to do anything. The licensee can just stand and sit back, and if the government has not met its burden, then the licensee, of course, can argue that the case should be dismissed because the government has not met its burden. I was just trying to ask for clarification. Okay, we're fine then. Does the government wish to make an opening statement?
Yes, Mr. Chairperson.
Yes, sir.
All right. Good afternoon, Mr. Chairperson and board members. We are here today in the show cause matter of Empire DC LLC, trading as Empire Lounge. The show cause notice issued in this matter concerns the charge that the licensee played music at such an intensity that it was heard in a premises outside of the licensed establishment, in violation of DC Code Section 25-725A. The district has the burden of proving by substantial evidence that the establishment violated DC Code Section 25-725. That standard is set by this board's regulations, specifically 23 DCMR Section 1711.6. The facts will establish that on Saturday, October 30th, 2021, Alcoholic Beverage Regulation Administration investigators Felicia Dantzler and Mark Brashears visited the establishment and determined that it played music with such intensity that it could be heard outside. At approximately 12:26 a.m., Supervisory Investigator Brashears received a complaint through the ABRA hotline concerning noise coming from the establishment. He forwarded that complaint to Lead Investigator Dantzler, who that morning was working on the noise task force. The investigators verified that the noise was audible outside of the establishment. Investigator Dantzler then contacted the complainant and asked to verify if the music was audible within the home. Dantzler entered the home, ensured all windows were closed, and verified she could hear music. She then called Investigator Brashears, located still near the establishment, to confirm the music. Investigator Dantzler then discussed the complaint with the establishment's owner. After Investigator Dantzler discussed with the owner, Investigator Brashears confirmed that the establishment is located in an Arts 2 zoned district. Under DC Code Section 725B, establishments located in either a commercial or manufacturing district are exempt from a noise violation enforcement. According to the District of Columbia Municipal Regulations, Arts 2 District is a special purpose zone created to emphasize residential development. In this agency's interpretation of DC Code Section 725B, Arts 2 is neither a commercial nor manufacturing district. As the District of Columbia Court of Appeals stated in the District of Columbia Department of the Environment versus East Capitol Exxon, agencies are entitled to deference in the interpretation of the statutes they administer. At the end of this hearing, the district requests that the board apply a penalty consistent with DC Code Section 25-830. Thank you.
Good afternoon. Mr. Bianca, do you wish to make an opening statement, or do you defer until you present your case, sir?
I would like to make a brief opening statement, and with sensitivity to the board schedule today, I will cut right to the chase. Even if we assume that the government could make its burden on the practical elements of noise, their case fails on the zoning element. Arts 2 is unquestionably a commercial zone, and to aid in the presentation of our case, we have two exhibits that are part of the law and public record that we'll be asking the board to take judicial notice of, specifically the 2016 Zoning Atlas, which is referenced in the text of 25-725, and second, the committee report on the ABC Procedural and Technical Amendment Act of 2020. And what that document does is it explains the most recent change to 25-725. This particular address And this particular residence has always been and remains in a commercial zone. The change of the nomenclature in 2016 by the zoning board does not impact the usage or boundaries of this particular zone. The agency's interpretation of 25-725 and the associated zoning regulations is inconsistent and incorrect. Based on that, they are not entitled to the deference afforded by the Court of Appeals, which is a general statement where the agency applies its regulations consistently. They have not done so here, and the evidence at the end of this hearing will show that. Thank you.
But so let me ask you a question, counsel.
Yep.
Is your client contesting the fact that the complaint, the noise complaint, that there was a noise complaint? The purpose of this case is that there was a complaint that was filed by the community that Abra did an investigation and confirmed that the noise was coming from this licensee. Is that being contested?
Not at all.
So what's being contested? It's the application of the law is the application of the law, because factually, so we don't need to have testimony, because factually, I'm asking,
yeah,
factually, what the government asserts is correct, that there was a legitimate noise complaint that was filed, and that the agency did investigate it. It was investigated, and that it was confirmed.
Well, what I would say is, as to those practical elements of the noise complaint and the investigation of the noise complaint and the substantiation of the noise complaint, we have no dispute. I think where we have an issue that may require some testimony is on the issue of whether an ARTS2 zone, or I'm sorry, the agency's interpretation of whether an ARTS2 zone is commercial. And just to sort of pull back the curtain, my planned cross-examination was, where does this determination come from? Is it part of a written policy? Is it common knowledge? Who makes the determination? All of these things, I think, factually bear on the interpretation of the statute.
And Mr. Jordan, and with where we are, I'm not sure I'm asking you, because as I said before, it doesn't make sense for us to have testimony on it's the interpretation. So I'm not going to tell you how to do. Well, you know what it is. This is what I'm going to do. Present your case, because this might be a case. This might be a case that, depending on whatever decision the board makes, this is a case that could be appealed. So therefore, I want to make sure that we have a proper administrative record. So I'll have you present your case, sir, in the way you plan to present your case, keeping in mind the arguments that's been made by counsel. All right. You have a witness, sir.
Yes, Mr. Chairperson. The district calls lead investigator Felicia Dantzler.
Ms. Dantzler, can you raise your right hand, please? Do you swear or affirm to tell the truth and nothing but the truth?
I affirm.
Thank you. Your witness, sir.
Thank you. Investigator Dantzler, could you please state and spell your name?
Felicia Dantzler, F like Frank, ELICIA, D like David, ANT like time, Z like zebra, LER.
And where are you currently employed?
The Alcoholic Beverage Regulation Administration.
And what's your position at this administration?
Lead investigator.
And how long have you been a lead investigator?
3 years.
And what are your duties and responsibilities in that position?
I investigate establishments that sell alcoholic beverages, and I conduct regulatory inspections of said establishments.
And where were you assigned on October 30th, 2021?
I was assigned to work the Abra Noise Task Force.
Could you explain what this task force is?
The task force generally runs from April through October of that particular year. With the investigator is assigned an investigator from the Department of Consumer and Regulatory Affairs who is experienced with a noise meter. And we have a determined list of establishments that we visit. And we also respond to calls that come into our hot phone for noise violations.
Okay. And are you familiar with Empire Lounge? How are you familiar with the establishment?
I have conducted several investigations involving the establishment or had to deliver some sort of legal notification. And I also had to go to the establishment for noise matters.
And on October 30th, did you have cause to visit Empire Lounge?
Yes.
And why did you visit Empire Lounge?
My supervisor, Mark Brashears, telephoned me to state that a noise complaint had come in.
And how did the agency receive this complaint?
Through the cell phone, the hot phone that the supervisors carry.
Okay. And after you were informed of the complaint, what were your actions?
To going to the establishment, S.I. Brashears provided me with the complainant's address. And so I looked up the complainant's address to ensure that the complainant was in a zone that gives standing for us to regulate.
And why did you ensure the zoning of this establishment?
I had to ensure that the complainant resided or in a zone that will allow that person to have standing. So if the complainant resided in a commercial or a manufacturer zone, that would exclude them from me enforcing the complaint.
Okay. And after verifying the zoning of this complainant, what were your next actions?
I made my way to Empire Lounge and arrived maybe approximately 20 or so minutes later.
Okay. And did you meet with anyone there?
Yes, I met with S.I. Brashears. I was in the company of Christopher Peters, who was the DCRA investigator who was assisting me that night.
Okay. And once you met with Investigator Brashears, did you do anything to determine whether noise was emanating in the area?
Yes, when Investigator Peters and myself arrived, we saw S.I. Brashears was standing a few doors away from Empire. And then I asked him, where did the complainant reside? Which he told me was behind Empire Lounge. And so we went to the rear of the establishment. And from there, I could hear some bass coming from the rear of the establishment.
And how did you verify that that was the rear of the establishment?
The establishment's address, the numerics are on the back door.
Okay. And so once you verified that was the establishment, what did you do next?
Then asked S.I. Brashears for a contact number for the complainant. And I then called the complainant and identified myself and asked if he was still willing to have an ABRA investigator enter his home to see if music could be heard within his residence.
And did you enter the complainant's home?
Yes, prior to going, I asked SR Rashears if he could remain in the alley. So I can communicate with him once I was inside the complainant's home.
And within the home, what were your steps to determine whether music was heard?
So the complainant met us like in the downstairs area outside his home, and when he welcomed us inside, the lights were on in the front room, and I also noticed a light on in a rear room. There was a female sitting on the couch, but there was really no sound in the front area. But I was distracted because I saw something from the corner of my eye, and I noticed that was the television that was on. But I didn't hear any volume from the television.
And were any windows open?
So no, the complainant asked Investigator Peters and myself to follow him to a rear room, which ended up being a bedroom. And as I was standing near the bed and in the window, I can hear some bass, some thumping inside his home.
Okay. And did you do anything to verify that that was the same noise you heard emanating from Empire Lounge?
Yes, prior to calling SI Rashears, I asked the owner if the complainant, if the window was open, and he stated that it was not, and I asked him to verify, and he just like automatically moved his hand and moved back the window covering, and I can see that the window was closed. So at that time, I then called SI Rashears, asking of him, was he still in the rear, which he confirmed he was. And I asked him, I asked him, did he, I hear thumping, is that what he hears? Kind of like some beats, moving, some bass moving, and he heard the same sounds that I heard inside the residence.
Okay. And would that substantiate the noise complaint? So what did you do afterwards?
I advised the complainant that that the violation was established and that I would create a report and advise the owner once I left his home.
Okay. And Mr. Chairperson, permission to share my screen?
Ms. Fossman, can you please allow Mr. Jordan to share his screen, please?
All right. Investigator Dantzler, I'm going to show you what is marked as Government Exhibit A. Mr. Chairperson, at this time, the district would like to confirm that what has been marked as Government Exhibit A is in evidence as under 17 DCMR, section 1713.10.
Yes, Mr. Jordan, it's on the board's record, so it is in evidence. Thank you.
Thank you, Mr. Chairperson. Investigator Dantzler, can you identify what this is, please?
Yes, that is my investigative report that I authored.
And are there any attachments to this report?
There's a zoning report.
Yes. And did you add this to the report?
I did. SI Rashears took the zoning report from took the zoning map from the zoning website and provided it to me for the report.
Okay. I'll stop sharing my screen. Investigator Dantzler, at any point while you were investigating this noise complaint, did the music ebb or seem to stop?
I can't say that it did or did not. Once I established the violation, I just returned to the front of the establishment and made my identity known and asked to speak with the ABC manager and owner. The owner stepped out and I advised him of the violation.
Okay. No further questions, Mr. Chairperson.
Mr. Bianco.
Yes. Good afternoon, Investigator Dantzler. So I understand from your testimony and your report that on Saturday, October 30th, you looked at the zoning atlases to determine that the complainant resides in an Arts 2 zone. Is that correct?
Not quite. I went to the zoning website and put in the address, and it came in the box that tells you on the left-hand side of the zoning page that I looked at, it advised me which zone it was in.
Okay. And that's how you determined it was in an Arts 2 zone?
Yes, sir.
Okay. And I believe I heard you testify that your understanding of the statute is that 25-725 does not apply to a residence located in a commercial or manufacturing zone. Is that an accurate recitation of your testimony?
Not certain if I stated residence, but my understanding of if the complainant isn't in that commercial or manufactured area, if they were in that commercial or manufacturing area, they had no standing to complain.
Okay. And on page 2 of your report, you indicate on Saturday, October 30th, a review of the zoning map by S.I. Brashears listed both Empire Lounge and the complainant's residence in an Arts 2 zone. And was it your testimony that that determination was made before you went out and investigated the complaint?
Yeah, those are two different actions, actually. So the first action I did prior to going to the establishment is when I looked up the information on my phone. The second action came after, during my crafting of my report, which was like a week or so later.
Okay, so here where it says on Saturday, October 30th, 2021, which is the same day as the complaint, a review of the DC zoning map by S.I. Brashears listed both Empire Lounge and the complainant's residence in an Arts 2 zone. Was that the search that you conducted on the day of the complaint, or was that referring to the search that Investigator Brashears did a week later?
That's concerned. That's S.I. Brashears' actions. I just looked. I never looked at the location of the establishment's zone.
Okay, so that October 30th date is actually, it should actually read that it's approximately a week later when S.I. Brashears conducted that search. Is that correct?
No, sir. What S.I. Brashears did on that night, I have no knowledge of what he did prior to me getting there.
Okay, but so what I'm driving at is I'm going to read the sentence and you can tell me what you mean by it. It says, on Saturday, October 30th, 2021, a review of the DC zoning map by S.I. Brashears listed both Empire Lounge and the complainant's residence in an Arts 2 zone. Could you please tell me when that search was conducted by S.I. Brashears?
You would have to ask S.I. Brashears that question.
Very well. So how did you determine on the day of the complaint that Arts 2 is not a commercial zone?
Because it doesn't state commercial zone and it didn't state manufacturer's zone. It would either be a C or an M. Sorry, hold on.
Okay.
I'm sorry, I'm in a room. Lights went out. My apologies.
Okay, so it's your testimony that because the zone is not named commercial and then a zone number, it doesn't qualify as a commercial zone. Is that a correct understanding?
Yes, sir.
Okay. And does the agency have a written policy on which zones qualify as commercial and manufacturing versus other types of zones?
I haven't seen one.
Okay. Is there some type of an unwritten or verbal policy to that effect?
No, we go by the statute that we follow that talks about referring to the DC zoning map for assistance.
Okay, so and who makes the determination whether a zone qualifies as commercial or not? Is that a determination made by the individual investigator or somebody else within the agency?
The DC Department of Zoning does.
I understand that the DC Department of Zoning publishes the different zones, but when you receive a complaint to the agency under 25-725, who within the agency decides whether or not that particular zone qualifies as commercial? Is the determination made by the individual investigator who fields the complaint or by somebody else within the agency?
I can't say what others do, but when I get complaints, I run the address. When there's a complainant, I run the address to see if they have standing. And if they have standing, then I take the steps that I did with Empire. And if they don't have standing, then I just make a notification to the establishment that, hey, you got a complaint. If you can turn down the music, that would be nice. But they're not, they don't have to.
Okay, so when you receive a complaint, you make a determination as to whether or not the zone qualifies as commercial. And after you make that determination, do you have to seek anybody else's approval of that determination, or is it within your discretion?
The approval comes through the DC zoning map.
Okay, but you don't have to ask somebody within the agency if your determination is a correct one.
Correct.
Okay. And do you give any consideration to how the zoning board, strike that. How do you treat mixed use zones for the purpose of determining whether or not it's commercial?
I don't read the definitions of the codes. I just look to see what their code is. So I don't go into the definition.
I understand. So the determination is based on how the zone is named by the zoning commission, correct?
Yes, sir.
Okay, great. Thank you very much, investigator. I appreciate your testimony.
Any questions by the board members?
Mr. Chairman?
Yes, Mr. Brandon.
Hi, investigator, thank you for being here today and your testimony on this matter. When the noise complaint was received by you, after you received that noise complaint, when was your first time that you went into Empire?
I got to Empire around, maybe, I think it was 250, I believe, or 150. I'll have to look at my report that I authored, but I know it took me around 20 minutes. Spoke with Investigator Bashir, so I was probably inside the inside the home within 2.5 minutes.
So just so I understand the timeline, upon receiving the complaint, when you went to that location, you went to visit the complainant, correct?
Yes.
Okay. And then you also stood in the alley at some point? Okay.
Yes.
Did you go into Empire prior to writing up the violation or after writing up the violation?
After.
So is it procedures by our investigators that when there is a noise complaint, that one of the investigators would be going inside the licensee while the other was either in an alley or in the complainant's apartment?
It actually varies whether the investigator who's staying at the establishment, if they go inside.
Okay. And to your knowledge, and I think your report had an indication of other licensees nearby. Were you able to determine if any establishment nearby also was having music played?
That wasn't my focus. Empire was the only establishment I was focused on. Although 9th Street is always bustling, you know, you hear music. The oddest thing is that you can go to the rear of the establishment and it's quiet. So it's easy to determine where the sound is coming.
Okay, so thank you very much. Thank you for that.
Any other questions by any of the board members? Mr. Bianca, any follow-up based on the question that was asked by the board?
No, Mr. Chair.
Mr. Jordan, a redirect?
Some redirect, Mr. Chair. Investigator Dantzler, just to confirm, prior to investigating Empire Lounge, you did determine what zone they were in?
Yes, sir.
And after the investigation occurred, Supervisory Investigator Brashears also investigated the zoning of Empire Lounge.
I don't know, when you say investigate, I don't understand. I'm not clear what other steps SI Brashears took, but I do know that he presented me with the zoning map.
Exactly that. No further questions, Mr. Chair.
Thank you, Ms. Dantzler, for your testimony. You're free to go. Mr. Jordan, do you have another witness?
Yes, Mr. Chair. The district calls Supervisory Investigator Mark Brashears.
Supervisor Investigator Mr. Bashir, can you please raise your right hand, please? Do you swear or affirm to tell the truth and nothing but the truth?
I swear.
You're a witness.
Thank you, Mr. Chair. Investigator Brashears, could you please state and spell your name for the record?
First name is Mark, M-A-R-K. Last name is Brashears, B-R-A-S-H-E-A-R-S.
And where are you currently employed?
The Alcoholic Beverage Regulation Administration.
And what's your position there?
Supervisory investigator.
And how long have you been a supervisory investigator?
Over 3 years.
And what responsibilities do you have in that position?
I basically supervise a team of 5 investigators whose job it is to go out and conduct inspections and investigations of ABC licensed establishments throughout the District of Columbia.
And are you familiar with Empire Lounge?
I am.
How are you familiar with it?
In addition to, routine visits to 9th Street and being familiar with the establishment, I received a noise complaint on Saturday, October 30th.
And what's the normal procedure to go through once you've received a noise complaint?
Well, in this instance, we had the noise task force operating. So I reached out to lead investigator Dantzler. She was assigned to the noise task force, but due to atmospheric conditions that evening, it had been raining off and on. The DCRA inspector assigned to the noise task force could not use his noise meter. So at that point, I realized we would have to substantiate it by going into the residence. So I told her that I would meet her over there.
Okay. And so once investigator Dantzler arrived, what were your next steps to substantiate the noise complaint?
We, myself, investigator Dantzler, and the DCRA inspector basically walked the alley and pinpointed that the music and the bass that we were hearing was coming from the back of Empire Lounge.
And how did you know that that was Empire Lounge?
The establishment's address is written on the rear door.
And so once you identified the noise came from Empire Lounge, what were your next steps?
I gave the contact information of the complainant to investigator Dantzler. She made contact with him, and L.I. Dantzler and the DCRA inspector visited the complainant's home.
And what did you do while the two investigator Dantzler and Inspector Peters were in the complainant's home?
I stayed in the alley directly behind the establishment, Empire Lounge.
And while you were there, did the music seem to flow or change volume?
No.
And did investigator Dantzler contact you from the complainant's home?
She called me via telephone. Yes, sir.
And what did you do with on that call?
She asked me to describe what I was hearing, so I basically mimicked the beat and the lyrics that I could hear, and she substantiated that she was hearing the same beat inside of the complainant's residence.
And so once the complaint had been substantiated, what were your next steps?
Well, after that, investigator Dantzler and the DCRA inspector Peters visited the establishment to notify the establishment of the complaint.
And did you further investigate the establishment?
Mr. Bashir, I think he's frozen. Mr. Bashir, can you hear us?
I apologize. It seems that the connection is cutting in and out.
Yes, sir, you are. There was a question. They need to repeat the question, please, Mr. Jordan.
And Investigator Brashears, did you investigate the establishment further after Investigator Dantzler made contact?
I'm sorry, Mr. Jordan. It's coming through garbled.
Rephrase. Investigator Brashears, did you investigate the establishment's zoning?
Yes, I did.
And what did you determine the zone for the establishment was?
So I'm somewhat familiar with the area, but prior to going over, I looked up the zoning, and later in the evening, actually printed the map that I provided to L.I. Dantzler. But what I determined, basically looking at the zoning, it was listed as an Arts 2 designation.
Okay. And Mr. Chairperson, I'll now share my screen.
Do you still have the ability?
Yes, Mr. Chairperson. Investigator Brashears, let me know if you can see what I'm currently displaying.
I can see it.
Is this the zoning map that you looked up?
Yes, sir, it is.
And can you identify the establishment on this map?
It is the darker shaded grayish blue square with the dot in the middle.
Is this a correct kind of square?
Yes.
And what does this map display the zone that the establishment is in?
It does.
And what zone is that?
It's Arts 2.
All right, thank you. Stop sharing. No further questions at this time, Mr. Chairperson.
Thank you. Your witness, Mr. Bianca.
Thank you. Investigator Bashirs, you were here for Investigator Dantzler's testimony, correct?
I was.
Okay. And it was her testimony that the determination of whether a particular zone qualifies as commercial is based on the name of the zone. Is that your understanding of how that determination is made?
So basically, we go off of 25.725, where it talks about the commercial and manufacturing zones. As she said, basically individuals living in those zones would not have standing. So based on that, any C1, 2, 3, or 4 or M class zone would not have the ability to make a complaint. I mean, they could, but they wouldn't have standing based on where they reside.
Okay, so the agency's position, and I just want to make sure I have the testimony correct. The agency's position is any zone that is not labeled C1, C2, C3, C4, CM, or M does not qualify for this exemption. Is that correct?
Those are the exempt, yes, sir.
Okay. Would it surprise you to learn that those zones that were just listed no longer exist?
I would not be aware of that, sir.
Okay. For purposes of, strike that, never mind. I have no further questions. Thank you very much.
Any questions for the witness? Any redirect, Mr. Jordan?
No redirect, Mr. Chairperson.
Thank you, Mr. Bashirs, for your testimony. All right, Mr. Jordan, do you have another witness?
No further witnesses, Mr. Chairperson.
Do you arrest, sir?
Yes.
Mr. Bianco.
Mr. Chair, I don't have any witnesses. We did submit 2 exhibits that are public record and I think actually part of the law.
What are the documents that you submitted?
Sure. Exhibit number 1 is the 2016 zoning atlas map of this particular location. And if it helps the board, I intend to submit written findings of fact and conclusions of law, which will refer to the documents and give the board the opportunity to consider them more fully. So exhibit number 1 is just a printout of the zoning map from 2016, which is prior to the zoning change. And exhibit number 2 is just the committee report from the 2020 amendment to the ABC Act, which is called the Technical and Clarifying Amendment of 2019. And it is as published by the council, the Committee on Economic Development, which again, we intend to simply refer to in our proposed findings of fact and conclusions of law. I don't think either of those 2 things are terribly controversial.
Mr. Jordan.
No objections to the exhibits, Mr. Chairperson.
So moved. I guess you further you stated that you're going to do findings of fact and conclusion of law. So I assume you're going to explain to the board why the committee, what the relevancy of the committee report to what we have to to determine today. All right. Anything else you want to say, sir?
Nothing else from the respondent in this case. I know the last time we did one of these, the board wanted to hear a brief oral closing. I'm glad to do that if the board prefers, but don't really feel terribly moved to.
DRS on I guess you're gonna do some legal submissions and to DRS.
Yes.
Mr. Jordan, do you wish to make a closing statement?
Yes, Mr. Chairperson.
Go ahead. Go ahead, sir.
Mr. Chairperson and members of the board, the district has met its burden under 23 DCMR section 1711.6 and has proven by substantial evidence that the licensee played music heard within a neighboring home in violation of DC Code section 25-725A. You heard from both lead investigator Dantzler and supervisory investigator Brashears, who verified the complaint on October 30th, 2021. The investigators identified Empire Lounge as the source of music within the neighborhood. Investigator Dantzler then visited the complainant's home while investigator Brashears remained outside. Once investigator Dantzler confirmed that no windows were open, she contacted investigator Brashears to verify the noise heard. Both investigator Dantzler and Brashears confirmed that they heard the same bass, the same lyrics, and the same music emanating from Empire Lounge in the complainant's home. Testimony also demonstrated that the investigators informed the establishment their music was audible outside of the establishment. Investigator Brashears then confirmed the establishment's zoning. Empire Lounge is located in a special use zone designated Arts 2. According to zoning regulations, specifically 11K DCMR section 800.3, the purpose of Arts 2 zone is to permit medium density mixed use development with an emphasis on residential development. This area is an intended residential zone, not commercial or manufacturing. An agency's interpretation of the statute it enforces is entitled to deference, as the DC Court of Appeals held in the District of Columbia Department of the Environment versus East Capital Exxon. Here, the agency has enforced the statute to prevent noise emanations in residential districts. Unless that interpretation is unreasonable or inconsistent, it is entitled to deference. The district has therefore proven the charge in the notice to show cause that the establishment emanated music audible in a neighboring home. The district recommends that the board apply a penalty consistent with DC Code section 25-830. Thank you.
Thank you, Mr. Jordan. I need to ask you this, Mr. Bianco, so do you want to make a closing statement or not?
Yes, I will. I'll make a brief one just to give the board some guidance as to where we're going. Our argument in this case is that an Arts 2 zone is commercial. The government cannot and has not shown that it isn't, and the basis for this statement is twofold. One, Arts 2 allows for commercial uses. There was a comprehensive overhaul of the zoning code in 2016, and in that overhaul, the Zoning Commission created dozens of zones, substantially all of them, every single one, allow some type of residential use, with the exception of some special waterfront zones and manufacturing zones. But the opposite is not true. A number of residential zones are exclusively zoned for residential and no commercial uses. Those are the zones that this law was intended to protect. Second, the legislative history of 25-725 supports our position. As I mentioned, the zoning code was overhauled in 2016, and in that redrafting, the zones C1 through C5, CM, and M were completely eliminated. The uses are still there. They just changed the names. So as it stands today, as we sit here, 0 zones in the District of Columbia are called or named commercial. None. Under the old code, the property at issue here, where the residence as well as the establishment is located, was labeled Arts C2. Following the 2016 amendment, given the change of the zoning nomenclature, the zone was renamed to simply Arts 2 as the C2 designation was eliminated. The boundaries have not changed. The uses have not changed. Now, under the prior version of 25-725, that was in effect under the old zoning pre-2016, C1 through C4, CM, and M were specifically exempted, and this property lied within a C2. 25, the revisions to 25-725, as the committee report will demonstrate, was a technical and clarifying amendment. It was not a substantive amendment changing the law or its interpretation. However, notwithstanding the change in both the zoning law and 25-725, the agency is not interpreting the law properly. They are still interpreting the law using the old code that no longer exists. The government can't even present a straight face argument that this is somehow consistent. The government can't make its burden in this case based on the evidence presented that this property does not lie within a commercial zone. We look forward to hashing this out more clearly in our proposed findings of fact and conclusions of law for the board's consideration. And as a practical matter, I think it's important to note here that this isn't for us about a $350 secondary tier violation. This case is the third case based on the same complainant, and it is going to keep happening and happening and happening unless we have a ruling with respect to this zoning issue, which is why it is incredibly important to my client. We have the situation here that we run into repeatedly on 9th Street, which is people moving to a place that they consider to have nuisance uses and then subsequently complaining about it repeatedly. And we think in this particular case, it is very, very clear that 25-725 does not apply. And we hope the board comes to that conclusion.
Thank you, Mr. Bianco. The record is now closed, and as stated by counsel, it's the applicant, the licensee's position that they are going to file proposed findings of fact and conclusion of law. Is that correct, Mr. Bianco?
Yes, sir, that is correct.
And Mr. Jordan?
Yes, Mr. Chairperson.
90 days from the receipt of the proposed findings of facts and conclusion of law, the board will issue a decision. The proposed findings and conclusion of law are due to the board 30 days after receipt of the transcript. The transcript will be emailed to the parties within the next 3 weeks. If they change their mind about the filing, they should inform the opposing party and the board. All right, so hold on, give me a minute, please. As chairperson of the Alcoholic Beverage Control Board for the District of Columbia, and in accordance with DC Official Code Section 2575 of the Open Meetings Act, I move that ABC Board hold a closed meeting for the purpose of seeking legal advice from our counsel on case number 21 CMP 00062 Empire Lounge, pursuant to DC Official Code Section 2575B 4A of the Open Meetings Act, and deliberating on case number 21 CMP 00062 Empire Lounge for the reasons cited in DC Official Code Section 2575B13 of the Open Meetings Act. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. I will now take a roll call vote on the motion before us now that it's been seconded. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Henson,
Jenny Hansen, I agree.
Mr. Grandis,
Edward Grandis, I agree.
and Mr. Anderson, I agree. As it appears that the motion has passed 6-0, I hereby give notice that the ABC Board will recess these proceedings to hold a closed meeting pursuant to Section 2575 of the Open Meetings Act. Again, I would like to thank the parties for their presentation today, and we are adjourned as far as this case is concerned. Thank you very much and have a great day.
Thank you, Mr. Chair.
Thank you, Mr. Chair.
You're welcome. You're welcome. All right, the next case in our calendar is a summer suspension hearing case number 22-251-00007, Cloud Restaurant and Lounge Sports Bar, license number 93572. Would the Ms. Foshbaum, can you please elevate the rights of the parties in this case, please?
Please stand by. Antoine Williams, your rights have been elevated. Richard Bianco's rights are already elevated. Or they were.
I think Mr. Bianco stepped away, I see.
I think he might have left. And I don't see the investigator either.
All right. I don't know what happened to Mr. Bianca. He just did our case, so I'm not quite sure why he would have stepped away. Mr. Williams. Mr. Williams. Ms. Foshman, I see that as Mr. Williams' rights been elevated, as his line's been unmuted because he's not responding. Mr. It's Mr. Cello.
Yes, sorry, Mr. Chairperson. I'm having an issue with my camera here, it appears.
All right, it appears that do either attorney have a number for Mr. Bianco? Mr. Bianco was just online in another hearing, and he
I can
stepped
reach out
away.
to Mr. Bianco, Mr. Chairman.
All right, thank you.
And I will be lead counsel for the Cloud Lounge matter. I just texted him. I'll send an email as well.
Okay, thanks. He was just online in another case, so I'm not sure why he logged off.
Richard
He
Bianco
just
is
logged
present.
back on.
Thank you. Mr. Bianco, all right. This is the summer suspension hearing for case number 22-251-0007, Cloud Restaurant and Lounge Sports Bar. Let's have the parties introduce themselves for the record, starting with the government, please.
Assistant Attorney General Anthony Cello for the government, ANTHONYCELO.
Good afternoon, Mr. Solo. Mr. Bianco.
Good afternoon again, Mr. Anderson. Richard Bianco for the respondent, last name spelled Bianco.
Good afternoon, sir. All right, this is a summary suspension hearing. We had a hearing scheduled for last week. The parties had told us that they were working on some type of offer in compromise, so we have the hearing today. So where are we this afternoon, Mr. Cello?
We have reached an offer in compromise that has been agreed upon by the parties.
And what are the terms of the offer in compromise, please?
The offer in compromise is about 5 pages. I can read it into the record if you like, Mr. Chairman.
Yes, you have to read it in the record, and then I have to read it into the record also. So, yes, please read the offer in compromise in the record.
Very well. In the matter of CAT LLC, TA Cloud Restaurant and Lounge Sports Bar, the District of Columbia, jointly with the licensee respondent, submits this offer in compromise, OIC, to the Alcohol Beverage Control Board. The board, as authorized by 23 DCMR 1604.5 for approval by the board. Parties understand that if the board approves the OIC, this case will conclude. Respondent will be obligated to abide by the terms of the OIC shown below. If the board does not approve the OIC, litigation of the summary suspension will continue. By accepting this OIC, respondent does not admit to liability. Respondent has been advised that there is no obligation to accept an OIC. Respondent has been advised through service of the notice of summary suspension that any summary suspension hearing or other proceedings respondent may be represented by legal counsel, have subpoenas issued to require the production of witnesses and evidence, produce witnesses and evidence, cross-examine witnesses, and apply to the board for a qualified interpreter. The OIC terms are as follows. 1, revised security plan. Respondent shall submit an updated security plan to ABRA and the Office of Attorney General, OAG, by 5 p.m. on April 4th, 2022. The security plan shall comply with all applicable requirements under DC Code Title 25 and corresponding regulations, including 25 DCMR 402. The revised security plan shall be reviewed and accepted by the board prior to lifting the suspension of the establishment's ABC license. The revised security plan shall include the following terms. A, the minimal requirements outlined under the existing security plan shall remain in effect unless otherwise outlined below. B, requirements that all patrons shall be subject to search by metal detecting wands and physical examination of any bags or purses brought into the establishment, with subsequent pat-down searches being supplemental as necessary. C, requirements for preserving a crime scene or scene of a violent incident, including that the licensee shall cooperate with any investigations conducted by MPD or ABRA, and that their employees shall stay and be interviewed by MPD in the event that a crime has occurred. The licensee agrees to submit a list of all security personnel employed by the establishment, which will be kept on premises, with the job title or role of each employee listed and their contact information. Such list shall be updated upon the hiring or termination of each security employee and shall be available at the establishment upon request by MPD or ABRA. D, requirements that all security cameras are maintained in working order at all times, and where the respondent knows or should know that the cameras are inoperable, respondent will follow the procedures set forth in DC Code 25-402, 403, E3G. E, requirements that training on how to identify and handle intoxicated patrons, de-escalation of threats and violence, and on reporting incidents of violence and injury to the manager, security supervisor, or other appropriate authority shall be conducted biannually for all staff and security personnel, and new staff and security personnel shall be trained on the security plan within 30 days of hire. F, all staff and security officers shall be trained on the revised security plan prior to the board's reinstatement of respondent's ABC license. 2, security cameras. Prior to the board lifting the suspension of the ABC license, respondent shall ensure that all 16 cameras currently in place are in full working order and that footage from all cameras is capable of being saved and maintained for at least 30 days. 3, fine. Prior to the board lifting the summary suspension of the ABC license, the respondent shall pay a fine in the amount of $2,000 for violations of their security plan, provided, however, that by entering into this offer in compromise, respondent does not admit liability for the violations. In no event shall the fine be paid later than 30 days from the board's acceptance of this OIC. 4, compliance walkthrough. Prior to the board's lifting the suspension of the establishment's ABC license, an ABRA investigator shall conduct a walkthrough of the licensed establishment with respondent to evaluate the establishment's compliance with the requirements outlined above. 5, suspension. The summary ABC license suspension shall be lifted upon satisfaction of these conditions, specifically 1, the repair of any inoperable cameras, 2, revision of the security plan, 3, training of all staff and security officers on the revised security plan, 4, successful walkthrough by ABRA, and 5, payment of the fine. And from there, it's signature lines.
Mr. So. Hi, Mr. Bianco. It's my understanding that offering compromise, and the offering compromise was just stated on the record by Mr. Sello. Is this your understanding, your client's understanding of the offer in compromise, sir?
Yes, sir, it is.
And is your client aware that by accepting an offer in compromise that they give up their right to a hearing?
Yes, sir.
And is your client also aware that by accepting an offer in compromise that they give up their right to appeal this matter?
Yes.
Mr. Fellow, I have a couple of questions I want to ask you. This was a summary suspension hearing, and this is offer in compromise. Is it your view that if the board was to accept this offer in compromise, that the emergency situation that while we're here today would be addressed by the terms of this offer in compromise?
Yes, Mr. Chair, by the terms of the offer in compromise, once all the steps have been accomplished, we believe that the emergency situation will have been resolved.
All right, thank you. And he also believes that this, if the board was to accept the offer in compromise, that this is in the best interest of the residents of the District of Columbia.
Yes, the government does believe that.
Any questions by any board members regarding the terms of the offer in compromise? All right, hearing none. I'm going to make a motion that the board accepts the offer in compromise. And I know that Mr. Fellow placed the terms of the offer in compromise in the record earlier. The offer in compromise consists of 5 terms, meaning that number 1, I'll just summarize that they have to revise their security plan and provide that to the agency by 5 p.m. on April 4th. And number 2 is that there's a provision regarding security cameras, that all 16 security cameras have to be in operation and that they're capable of maintaining the recordings for 30 days. Number 3, there's a fine of $2,000, and that should be paid before they will be open to reopen. And the fine has to be paid no later than 30 days. But number 4, that the agency will do a walkthrough prior to lifting the suspension. And number 5, the conditions are that repair any inoperable cameras, revision of the security plan, train of all staff and security officers in a revised security plan, and successful walkthrough by ABRA and payment of the fine. I know that I summarized it, but Mr. Seller did a great job putting the terms of the offer in compromise in the record. So with that, I make a motion that the board accept the offer and compromise. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now have a roll call vote on the I'm sorry, roll call vote on the motion. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Henson,
Jenny Hansen, I agree.
and Mr. Anderson, I agree. The matter passed 5-0. I want to thank the parties for working this matter out, and I trust that as the representation by the government, that this is in the best interest of the residents of the citizens, the residents of the District of Columbia. Thank you very much for this, and have a great day. Thank you.
Thank you, Mr.
Chair.
Bye. The next case in our calendar is the protest hearing, case number 21 PRO 00085, Spar Liquors, license number 105207. This hearing is canceled due to the submission of a settlement agreement provided to the board for its review and approval. Right, so we're at the end of our calendar for the day. So let's now do our board, our legal agenda. All right. In our legal agenda, the first matter on our legal agenda is a review of a settlement agreement dated February 8th, 2022 between Advisory Neighborhood Commission 6B and Newland, license number 120239. I make a motion that we approve this request. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote on motion. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Anderson, I agree. The matter passed 5-0. Number 2, review of a settlement agreement dated November 3rd, 2021 between Advisory Neighborhood Commission 4C and Petworth Cigars. I make a motion that we approve this request. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote to the motion. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Henson.
Jenny Hansen, I agree.
Mr. Anderson, I agree. The matter passed 5-0. Number 3, review of request to reinstate canceled license dated March 29th, 2022. This is for Momo Maya, license number 074714. I make a motion that we approve this request. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded this motion. We'll have a roll call vote on the motion. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Hanson.
Jenny Hansen, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. Number 4, review of the Chief of Police request for a fact-finding hearing dated February 26, 2022. This is Bravo, license number 113585. I make a motion that we approve this request. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now have a roll call vote on the motion. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Hanson.
Jenny Hansen, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. We now move to our licensing agenda. First matter on our licensing agenda is review application for safekeeping of license. This is for Paul Discount Wine and Liquor, license number 0000010. I make a motion that we approve this request through September 30th, 2022. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote on the motion. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Hanson.
Jenny Hansen, I agree.
Mr. Mr. Anderson, I agree. The matter passed 5-0. Number 2, review application for safekeeping of license doing transfer. Safekeeping of license doing transfer. This is for Social Beast, license number 117089/120780. I make a motion that we approve this request through September 30th, 2022. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. Let's now have a roll call vote. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Henson,
Jenny Hansen, I agree.
and Mr. Anderson, I agree. The matter passed 5-0. Number 3, review application to extend safekeeping of license. This is for Wise Guy Pizza and Atlante Gelato, license number 112073. I make a motion that we approve this request through September 30th, 2022. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Hanson,
Jenny Hansen, I agree.
and Mr. Anderson, I agree. The matter passed 5-0. Number 4, review request to extend safekeeping of license. This is for to be determined, formerly Sterling Gunson LLC, license number 111806. I make a motion that we have a fact find on this matter. Is there a second?
Mr. Short, I second.
Mr. Short has seconded the motion. We'll now have a roll call vote. On the motion, Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Hanson,
Jenny Hansen, I agree.
Mr. Anderson, I agree. The matter passed 5-0. Number 5, review application for change of hours. This is for Studio 52, license number 115069. I make a motion that we approve this request. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote on the motion. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Hanson,
Jenny Hansen, I agree.
Mr. Anderson, I agree. The matter passed 5-0. Number 6, review application for tasting permit. This is for H Street Fine Wine and Liquors, license number 117405. I make a motion that we approve this request. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Hanson,
Jenny Hansen, I agree.
and Mr. Anderson, I agree. The matter passed 5-0. Number 5, review request for approval to provide a gift of retail window clings that do not exceed $500 in value to Covat Liquors, license number 106551, Silverman Liquors, license number 116401, McReynolds Liquors, license number 091013, Town Wine and Liquor, license number 093813. The request has been made from Breakthrough Beverage, a wholesaler, license 060518. I make a motion that we approve this request. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Henson,
Jenny Hansen, I agree.
and Mr. Anderson, I agree. The matter passed 5-0. Number 8, review request for approval to provide a gift of Tito's window clings that do not exceed $500 in value to Fair Liquors, license number 118886, Giant Liquors, license number 074791, Metro Wine and Spirits, license number 060602, Oceanfront Liquors, license number 096628. This request has been made by Breakthrough Beverage, a wholesaler, a license number 060518. I make a motion that we approve this request. Is there a second?
Mr. Short, I second.
Mr. Short has seconded the motion. We'll now have a roll call vote on the motion. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Henson,
Jenny Hansen, I agree.
and Mr. Anderson. I agree. The matter passed 5-0. We now move to our supplemental licensing agenda. The first matter on our supplemental licensing agenda is a review request for a temporary operating retail permit. This is for the Madison, Washington, D.C. Hilton Hotel, license number 120944. I make a motion that we approve this request. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We now have a roll call vote. Mr. Short.
Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. Number 2, a review request for a temporary operating retail permit. This is for the Madison, Washington, D.C. Hilton Hotel, license number 120945. I make a motion that we approve this request. Is there a second?
Mr. Short, I second.
Mr. Short has seconded the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. Number 3, review request to remove license from safekeeping to open for alcoholic beverage service on April 1st, 2022. This is for residents in Washington, D.C. Thomas Circle, license number 060397. I make a motion that we approve this request. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. Number 4, review a request for a personal auction permit for an event to be held on on April 4th, 2022. This is for Whiskey Shop DC, license number 120535. I make a motion that we approve this request. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote on the motion. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Crockett.
Rafi Crockett, I agree.
Henson.
Jenny Hansen, I agree.
And Mr. Anderson, I agree. The matter passes 5-0. We now move toward cancellation agenda. The first matter on our cancellation agenda, the ABC Board will be canceling the following license for the reason cited below. Crown Liquors, license number 088121, the license request cancellation. Church, license number 106963, the licensee requests cancellation. I therefore make a motion that the ABC Board grants the request to cancel license. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. We now move to the board's temporary one-day and substantial change docket. The first request, a request from James Battle for one-day license class F. This is for 50th birthday party. This is April 9th, 2022. The license number is 120918, 75 attendees, 2 security guards. I make a motion that we approve this request. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote on the motion. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Henson.
Jenny Hansen, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. Number 2 is a request from Anna Valera for a one-day license class G. This is for the Cherry Blossom Festival. This is on April 2nd, 2022. The license number is 120898 for 500 attendees. I make a motion that the ABC Board refers this matter back to licensing. Is there a second?
Mr. Short, I second.
Mr. Short has seconded the motion. We'll now have a roll call vote. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Henson.
Jenny Hansen, I agree.
And Mr. Anderson, I agree. The matter passed 5-0. Number 3, a request from Ranchel Shank for one-day license class G, annual nonprofit meeting and networking conversation for Georgetown Main Street. This is for April 6, 2022. The license number is 120912. 100 attendees, 2 security guards. I make a motion that we approve this request. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote. The motion, Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Hanson,
Jenny Hansen, I agree.
and Mr. Anderson. I agree. The matter passed 5-0. Number 4, a request from Zoffrey Zambrano. This is for one-day license class G, a wedding, April 9th, 2022. License number is 12091, 660 attendees. I make a motion that we grant this request. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Henson,
Jenny Hansen, I agree.
and Mr. Anderson. I agree. The matter passed 5-0. Number 5, a request from Aqua 301 Inc., a one-day substantial change. This is for the Petal Azolia National Cherry Blossom Festival change. This is the date of the event is April 16th, 2022. The rain date is April 17th, 2022. And this, the license number is 092094. I make a motion that we approve this request. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll have a roll call vote on the motion. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Henson,
Jenny Hansen, I agree.
and Mr. Anderson. I agree. The matter passed 5-0. Number 6, a request from Regmo Promos Inc. This is a pub crawl. This is the R&B pub crawl. The date of the event is June 18th, 2022. The license number is 104076. They're requesting 1,500 to a maximum of 2,000 attendees. I therefore make a motion that the ABC Board approves this event for 1,000 participants. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote. Mr. Short,
Mr. Short, because of public safety concerns, Mr. Short disagrees.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Hanson,
Jenny Hansen, I agree.
Mr. Anderson, I agree. The matter passed 4-1. We now move to a supplement to the board temporary one-day and one-day substantial change docket. And there's one request on that docket. It's a request from Kraken 340 LLC, trade name Hook Hall, Ana Valera. This is for one-day substantial change. The event is a one-day substantial change. Date of the event is April 2nd, 2022. The portion of the premises for 500 participants. The license number is 109296, and the substantial change number is license number 22SC00628. I make a motion that we approve this request. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. We'll now have a roll call vote on the motion. Mr. Short,
Mr. Short, I agree.
Mr. Cato,
Bobby Cato, I agree.
Ms. Crockett,
Rafi Crockett, I agree.
Ms. Henson,
Jenny Hansen, I agree.
and Mr. Anderson. I agree. The matter passed 5-0. We now move to our licensed administrative docket. On our licensed administrative docket, there are 35 applicants. I will read the name of all 35 applicants at the end of the list. I will make a motion that that we approve the licensees on this application. The first one is a request from Dama Q, license number 109538. A retailer A, liquor store, letter of request for an off-site storage permit at 500 Emerson Street Northeast. Number 2, a request from National Press Club, license number 0000001. Oh, the first license that was granted. Their retailer CX license, change of officer application to add Jennifer A. Judson as president. The next request, a request made by Kenneth H. Nash, Post 8, American Legion, a license number 000643. Their retailer CX, change of officer application to add David Carmichael as president. Number 4, so you have number 4, number 5, number 6, number 7, number 8, number 9, there's no number 10, number 11, number 12, number 13. All of those were for Giant of Maryland LLC. Giant, the license number 375, Giant number 378, Giant number 383, Giant number 384, Giant. I'm sorry, let me go back over the list. They have different license numbers, so I apologize. So let me go back over the list. I'll go over them one by one. Number 4 on the list is a Giant number 375, license number 060569, retailer B, a letter of request to remove Officer Gordon Reed as president. Number 5, Giant number 378, license number 072580, a retailer B, letter of request to remove Gordon Reed, president. Number 6, Giant number 383, license number 075065, a retailer B, letter of request to remove Gordon Reed as president. Number 7, Giant number 384, license number 077233, retailer B, letter to request to remove Officer Gordon Reed, president. Giant number 2376, license number 092843, retailer D, restaurant, letter of request to remove Officer Gordon Reed, president. Number 9, Giant number 2376, license number 092842, full service grocery store, letter of request to remove Gordon Reed, president. There is not a number 10, so we move on to number 11, Giant number 2379, license number 095375, full service grocery store, letter of request to remove Gordon Reed, president. Number 12, Giant number 2379, license number 095376, retailer D, restaurant, letter of request to remove Officer Gordon Reed, president. Number 13, Giant number 2381, license number 091952, retailer B, letter of request to remove Gordon Reed, president. Number 14, the George Washington University trade name 1 Washington Circle Hotel, Circle Bistro, license number 060309, retailer C restaurant. Retailer C Hotel, change of officer application, Charles K. Barber, interim general counsel. Number 15, Hyatt Place, Washington, D.C., Georgetown, West End, license number 114703, retailer C Hotel, change of officer application to add Chad M. Patterson, president. Number 16, trade name Hyatt Place, Washington, D.C., Georgetown, West End, license number 114703, retailer C Hotel, letter of request to remove Officer Bradley Berkey, president. Number 17, State Plaza Hotel, license number 078312, retailer C Hotel, letter of request to remove officers James R. Martins and Robert Truelove. Number 18, the Lombardi Cafe Hotel, license number 019070, retailer C Hotel, letter of request to remove James R. Martins. Remove Officer James R. Martins. Number 19, Morrison Clark Inn, license number 020149, retailer C Hotel, letter of request to remove Officer James R. Martins. Number 20, Henley Park Hotel, License number 009269, Retailer C Hotel, let up request to remove Officer James R. Martins. Number 2021, Renaissance Hotel, license number 085654, Retailer C Hotel, change of officer application, Aaron R. Reyes, CFO, and removal of John V. Arabia. Number 22, McIntyre's Pub, license number 096643, Retailer C Restaurant, entertainment endorsement application. Number 23, Grand Liquor, license number 120931, Retailer C Liquor, transfer of sale application. Number 24, Magpie and the Tiger, license number 120259, Retailer C Restaurant, New ABC license application. Number 25, Shellfish, license number 120258, Retailer C Tavern, New ABC license application. Number 26, to be determined, formerly Cava Restaurant, license number 120810, Retailer C Restaurant, transfer without sale into safekeeping application. Number 27, Ambassador Restaurant, license number 090422, Retailer C Restaurant, stock transfer application. Number 28, Taffer's Tavern, license number 119792, Retailer C Restaurant, New ABC license application. Number 29, Bindav Bowls and Rolls, license number 120487, Retailer C Restaurant, New ABC license application. Number 30, the Columbus Club, license number 107244, Retailer C Tavern, stock transfer application. Number 31, Rosewood, Washington, D.C. Hotel, license number 102245, Retailer C Hotel, transfer of ownership application. Number 32, Top Spanish Cafe and Catering, license number 084580, Retailer C Restaurant, transfer of ownership application. Number 33, Lions Fine Wine and Spirits, license number 120359, Retailer A Liquor Store, transfer with sale application. Number 34, Green Plate, license number 120942, Caterer license, New ABC license application. And number 5, One Washington Circle Hotel, Circle Bistro, license number 060305, Retailer C Hotel, change of officer application to add Mark S. Wrighton as president. I therefore make a motion that the ABC board approve these requests. Is there a second?
Mr. Short, I second.
Mr. Short, I second the motion. We'll now have a roll call vote on the motion. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. The matter passed 6-0. We've now come to the end of our calendar for the day, and so we're going to adjourn for the day. As chairperson of the Alcohol Beverage Control Board for the District of Columbia, in accordance with DC Official Code Section 2575B and Section 2575B14 of the Open Meetings Act, I move that the ABC Board hold a closed meeting on April 6, 2022, for the purpose of discussing and hearing reports concerning ongoing or planned investigations of alleged criminal or civil misconduct or violations of law or regulations, and seeking legal advice from our legal counsel on the matters identified on the board's legal, licensing, and investigative agenda for April 6, 2022, as published in the DC Register on April 1st, 2022. Is there a second?
Ms. Crockett seconds.
Ms. Crockett has seconded the motion. I will now take a roll call vote on the motion before it now that it's been properly seconded. Mr. Short.
Mr. Short, I agree.
Mr. Cato.
Bobby Cato, I agree.
Ms. Crockett.
Rafi Crockett, I agree.
Ms. Henson.
Jenny Hansen, I agree.
Mr. Grandis.
Edward Grandis, I agree.
And Mr. Anderson, I agree. As it appears that the motion has passed 6-0, I hereby give notice that the ABC Board will hold this closed meeting. Pursuant to the Open Meetings Act, notice will also be posted on the ABC Board hearing room bulletin board placed on electronic calendar in ABRA's website and published in the DC Register in as timely a manner as practical. We're now adjourned for the day. I would like to thank the members of the public who signed in this hearing today. I also want to thank the members of the ABC board for their active participation today. We're adjourned for the day. I now ask all ABC board members to return to executive session for further development. Thank you very much and have a great day.